stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, hello, hello. Happy Friday, everybody. It's been, I think, a few days since we've seen each other, at least on this channel. So welcome everybody back to Criminality, or if it's your first time here, welcome to the channel, and thank you for stopping by. We have quite a few things to go over today because it has been a few days since we've touched on this. But I'm going to say hi to everybody in chat, and then we'll go over all the fun things. Fun? I don't know if it's fun. I don't know why I say that. All the things. We'll just go over all the things. How about that? So, hi, Chicken Operas. What's up, Richard? Hey, Salty Beach. Mel Mac. Hi, Teresa. Hi, Heavy Metal Rehab. Vertinoga. Hi, Veronica. Happy Friday. It's Good Friday. And then Sniper, I don't know if you guys saw the comment in chat. Sniper is putting together a little, some visuals for us, and he's going to come up and talk to us about, like, tool marking, ballistic type things, because as you guys know, and I am very open about the fact that I do not know a ton about that stuff, so I am so looking forward to that and cannot thank you enough, Sniper, for doing that for us. Hi, Jaya. What's up, Nancy? Hi, Richard. I think I already said hi to you. Now I forgot who I even said hi to because I went off on a tangent. Hi, the Royal We. I haven't seen forever. Strictly Chaos. Inspector Gadget. Hi, Carla. Hi, Marshall. Hi, Sarah. Missed you. I missed you. I know it feels like it's been forever, Kiki. I know. Hi, AH. What's up, BR? Hi, Jen. What's up, Jeanette? Hi, Kaylee. Hello, Spring. What's up, Chelsea? Teresa. And if all the other Teresas are here and I miss you because I think I already said hi to you. Hello, all the Teresas. Hi, Women Doing Impossible Things. Hey, Shaz. Hi, Rose. Carla. Linda K. Schmeed. Hi, Unindicted. Odie Doty. Hi, Lord. Hi, Fiend. Lorna and Moonlight and Kelt and Christy. Hi, Susan. Just Dib. BG OG in the house. What's up, Scott? Hi, Anna. Mother of Dragons. Mother of Dragons. Hi, Brad. What's up, Francis? Hey, Mandy. Yankee Ghost is here and Dr. Von Decay. Hi, my King of Kings. And Laura, I have a private question I need to send you. Okay, do it. Do it. Hi, Randy Gravitt. Good to see you. Bella and Susie Q and Kaleida Hope. I think the hall feels the slap. Hi, Rose. First time I caught your intro. Very slick. Ooh, Patricia. Thank you. It's Christy. Richard. I think you have to laugh at this. Otherwise, you'd go crazy. I'm going to be very honest. I've been struggling with the YouTube Delphi the last few days. I feel like it kind of caught fire for a hot minute, and I was like, I don't even want to know. I don't even know what to say. It was so bad. 4 pit bulls across America. They are back up. Hi, KO. C Dub. Hi, Luis. Hi, Chris. Sweet dude. Shibby shibby. Hi, Kayla. JCM. Yeah, I was just, the last couple of days was just kind of rough. And I don't know, I was like feeling all the things. So what's up, Brandon? Hi, Catherine. Okay. From Loves Park. What? No way. Stop that right now. From Loves Park. Not too far from where I was born. Hey, CEO Mama. Hey, Tech Death. Okay, let's see. Hi, Freckled Joy. I'm holding a wall in the yard. I'm so bored. Salty Beach. I hope Gull changes her mind on making this trial accessible, but I doubt she will. I do not foresee that happening. I just don't. She's adamant. She's now just continuing to deny anybody who does request, anybody who, you know, all these people that are writing to her. As much as I understand the want to have the cameras, it's a struggle because I just don't think. Maybe you have to kind of do it for yourself, you know, to know that you did what you could on your part. But I'm telling you, she's not listening. So as much as and I'm not going to read through them. I know if you guys, over this last week, there's been like 3 letters that have been submitted by, you know, citizens of Indiana, and I think 2 of them were anyway, and then 1 was somewhere else, and she, you know, puts them on the docket, but, you know, it's just not going to happen. But they're citizens technically just requesting for her to reconsider, you know, putting cameras in the courtroom and having it. It'll be awful for us to watch anyway. It's going to be tough to watch, but here's my thing is that the transparency of what's happening in that courtroom, and we see from just a hearing on the 18th, you know, and like I said, I appreciate everybody that went. I appreciate everybody's notes that they took, but it's not the same thing. I mean, you know, we were trying to collect notes in order to compile them and put them in some type of cohesive order and make sense of them. Now, I mean, hopefully the transcript is going to come. I know that the one for the motion to dismiss was requested by citizens, but both the motion for contempt and the motion for dismissal were both requested by defense. But that's not for us. T, you should Google Earth the courthouse and tell me where in the world people are going to park, let alone find a space in the courtroom. I feel like she's going to have to come up with another solution. Yeah, I'm very proud. Yeah, hold on. Let me address this first, then I'll go back to the other point. But I'm very proud of the people who are trying to say, hey, like, listen to us. And I don't mean to like put a kibosh on it. I just don't know if that's the right way to go about it, because she's already saying no. So I don't know. And I don't know if it would take, like, is it going to take like 500 letters delivered to the courthouse, or I don't know. I don't want people to feel like they put effort into something and then they're still getting shot down. But I also know, like, sometimes it's just a personal thing. You have to put the effort in so that you know you did what you could. Now back to the courthouse. I'm hoping that she decides to put something in play to prevent the chaos that's going to happen. It's going to come upon Delphi during this trial. There's no hotels there. There's no parking there. I just cannot imagine that you're going to have tons of people who are going to come from all over the place to come to this trial because it's not being viewed or not being televised or streamed anywhere. I hope she puts something in place to, one, fix like how many people are going to be allowed in there. Like, if you know you have 30 seats, and I don't know how many seats there are in the courthouse, but if you know you have 30 seats, and you know you're going to have 100 people in line, like, there should be some form of lottery so that you're not just having 100 people standing out in Delphi. And it's going to be more than that probably, but you understand my point. So that there's like some type of lottery that, you know, the day before, whether you're getting into court the next day, that you are pulled as one of 30 that's going to have a seat. Otherwise, you don't show up, which would stop some of the chaos from happening. So even if people do come out there and are staying at like a hotel in Lafayette or staying somewhere else, they know not to drive. They don't need to drive to Delphi. So that's, Judge Gull, if you're listening, that's a suggestion. The other thing is, when Barry Morphew had his like preliminary hearing, they wouldn't stream it because another YouTuber streamed it when the order was for it not to be streamed. So they took it down. They took down the access to it. But what they did do was set up hi, C-Dub. Did I say hi to you? Hi, Hoodis. That they're all still, you're so funny. They're all still going. I know. But she set up like a streaming service for just the people who showed up. So if you were in line and they only took like one through 20, anybody from 21 and after was able to go over to like a park essentially and just watch the courtroom feed. So at least you got access for the fact that you came. I don't think she's going to do anything of anything. I think she just doesn't give a shit. I don't know. And that's like another reason I've just been kind of like I don't know. It's like you fighting against a system that just is so broken. It becomes just frustrating. It'll be like Black Friday sale in line. It'll be probably worse than the recent Black Friday sales because Black Friday sucks now because you can order everything online. Maybe writing to the Carroll County Council or the Delphi Mayor or Attorney General would be more effective. Ask for streaming to avoid chaos. They might have more influence than individuals. Well, I definitely believe that the citizens of Indiana, and more particularly the citizens of Delphi, Carroll County and then Delphi being the most important, it's way too logical. I know. I don't know. Bring a tent. Gull approves. She and Delphi are going to regret it. It's going to be a hot mess, cost them a whole lot, and they might get some back at gas stations and a few fast foods at lunch. Possible. Marcus, that worries me, taking the drive to get denied a seat. Yeah, absolutely. Do we still think this trial is going ahead? At this point, I am of the belief it's going to go ahead in May. I know that a lot of people are like, no, there's no way this is happening in May. I'll tell you my reasons behind this. One, and I'm going to show you a video too, because I know that it came out yesterday, but I'll show you guys anyway. That one is that she's already stated in the 18th hearing that she has sent out the surveys for jury selection. That's costly. So I don't think she's not gonna change it all willy-nilly. The second part is that she now, as of yesterday, has set a schedule for the trial and what she believes how the trial is going to flow. The first couple of days in Allen County, or first 3 days in Allen County, for jury selection, and then they will have swearing in of the jury, and then they will travel down to Delphi, where they are staying in a hotel, I would believe in probably Lafayette. And how weird is that going to be that you're going to like be in the courtroom and then like the jurors are going to be in the same hotel room or same hotel as you? That could cause, with the way that social media acts about this case, I don't know. They'll have the sheriffs with them though, so they'll be able to go around that way. And then so she has set it so that they'll come down, and then the trial, as long as there's not any religious issues with jury members, she plans on having the jury Monday through Saturday. So it'll be a 6-day-a-week trial. But I'll play that for you guys too. So that's not the right one. This one right here, so you guys can see that. Hi, Mez. Hey, hello. Okay, let's see. Come back over here. I live an hour away and used to work with 20 minutes of Delphi. Be very careful choosing hotels in Lafayette. Remington has a few decent ones right off of 65. Hennessy is something else. I appreciate that, man. We're gonna talk about Hennessy too, because he did a little interview today. They don't want the world to see all the corruption, but they'd rather that the social media chaos that, in my opinion, was brought on by law enforcement. They'd rather that all come to Delphi. And now how many cops are they going to pay to try to make sure that nothing happens? What other things are they going to have to do to ensure the safety of the people that are there? Hey, Johnny. The local media, especially Indianapolis, is really giving her bad coverage. They appear upset. All right, let's see. Let me put this on here for you guys. Make sure we have sound. Check. And if you guys cannot hear it, just let me know. But it should be okay. Pizza King better stock up on the dough. Pizza King's closed. There is no more Pizza King. Well, at least not the other one, unless somebody bought it and put it somewhere else. But that old one closed because the owner of it got arrested for doing bad stuff to kids.
Tonight, we're getting new details about the trial coming up in May for the Delphi murders.
Judge Frances Gull tells us how much time she wants for jury selection and for the trial. So Bob Siegel tonight breaks down the details.
We already know the Delphi Murders trial is set to begin May 13th. Judge Frances Gull set the trial date a few weeks ago. But this week, 13 News had a chance to meet directly with the judge, and she provided additional details about the upcoming trial for Richard Allen. Gull told 13 News she plans on jury selection taking approximately 3 days in Fort Wayne. The jury would then be sworn in on the 4th day, and opening statements would then take place on day 5. That means the actual trial would start on Friday, May 17th. Judge Gull confirmed the Delphi Murders trial will take place at the Carroll County Courthouse 6 days a week, Monday through Saturday, if there are no religious objections by any of the jurors. And the jury will hear testimony from roughly 9 till 5 each day. The Carroll County Courthouse closes at noon on Wednesdays, but the judge plans to keep the trial going on Wednesdays right through the end of the day. Judge Gull expects the trial to be complete by May 31st. So far, she has not approved any cameras in the courtroom. Keep in mind, both the judge and the jury will be from Allen County, and they'll be transported 100 miles to Delphi for the trial. The jurors will be sequestered the entire time. Arrangements have already been made for them to stay in a hotel close to Delphi. 13 News has confirmed the Allen County clerk has sent jury questionnaires to 600 Allen County residents. The jury will be chosen from among those 600 people in what's one of the most high-profile murder trials in state history. In case you're wondering, each juror will receive $80 a day for the first 5 days of the trial. After that, they'll get $90 a day. Those rates are set in state law. I'm Bob Siegel, 13 News.
Okay. So I found this kind of interesting on the calendar. Let me go back to it. She thinks it's going to be 3 days for jury selection. And then she thinks it's going to be 1 day. Oh, shoot, I didn't go back far enough. 1 day for the jury to be sworn in. Why would that take an entire day to swear in the jury? Hi, Skip. Good to see you. My father's very ill and have been. I'm very sorry to hear that. I miss my daddy. If she's prepared to go longer, or if she's going to give them time limits. Let me see. So I also found out the other comment that I found interesting was right at the beginning of the stream. He says that that Channel 13 was able to actually meet with Judge Gull. I found that to be intriguing. I was like, she took a meeting with the news station, like a face-to-face. I don't know. I found that kind of interesting. I was like, did she really do that? Like, otherwise, like, you talk to her when you say like I talked to her. I know like you guys give me all kinds of crap because like I pay attention to like weird words like that. But like they actually got to like sit down and meet with her. I don't know. That's weird. Seems it's not enough time allotted for the trial after seeing what happened at the hearing. I could not agree more. So if they do Thursday for swearing and the whole day, they're not even going to do opening statements until Friday. I don't know. That just seems so odd to me. Maybe she's just leaving it kind of open for the fact that maybe take a little over 3 days to pick the jury or whatnot. So opening statements on Friday, then they're shuttled down to Delphi, and then the trial's going to start then technically the 17th, 18th, and then go through 20 to 25. I mean, it would only be like 2 Saturdays. And for a jury that's going to be sequestered, I'd probably be like all for it. I'd be like, yeah, let's just do it. And then Wednesdays, the courthouse actually closes early and she's going to just stay and keep it open. But I mean, like other trials of this size just seem to take so much longer. I just am so, I don't know. It brings me back to, and I think I said this on another live that I did, was, do they really just not have that amount of evidence that they have to present? I mean, it doesn't seem, if you're looking at even, 6 days here and then the 5 days for the defense or 4 days for the defense, like, I don't know. I mean, she doesn't even have the witness lists. I don't know what they're planning on doing. I don't know. It just seems too short for me. But like I said, maybe they've got it and they're just like, no, this is how we're going to do it. She hasn't done any of the the hearings to like lead into having the trial yet to even really know. But maybe she's just like, no, well, I'm not going to pay for the defense experts, so they won't be testifying. So maybe, cut them off a couple days. I think the state will take 2.5 weeks. Not if they don't actually have anything to present, if they don't actually have a ton. 7 years of an investigation, over 1.5 years, almost 2 years since the guy was arrested, and it's only going to take them a little over a week to present their case. It's just crazy to me. It does seem like it's a weird cryptic secrecy. And this is what I said earlier. I think that what we see on social media currently, and obviously I think that some would take it to this extreme level anyway, because that's just personalities of people, some people on social media. But you have the law enforcement agents who have literally begged the public for help. When this happens, when these families, when law enforcement, when they're asking on the media for help, I think this is like the biggest catch-22, is people become highly invested in the case. They become emotionally invested in the case. And then in turn, they get mad that people are emotionally invested in the case. But it's like, you asked for the public's help, and in doing so, you made them feel like they're involved. You make the public feel like they're a part of the investigation. And then with the important things that you don't, you want to keep close to the vest, you don't tell the public, and then you end up with how we are now. So I feel like they created a lot of this. And then when you have even just the perception of law enforcement leaks, which I mean, obviously, I believe that there obviously has been. And people will say, like, well, there wasn't a gag order. And I say that too. Yes, a lot of the information there wasn't a gag order on, but some of the information that is being accused recently were things that were under seal at the time that they were shared, which is also going against the court order. So if it's sealed, it's sealed. I just feel like a lot of what we see right now is because of the way that the public was treated and included and then excluded. It's like a toxic relationship. That's where I'm at with it. It's like, you want our help, but you won't give us the most important pieces to help you. But then you're saying, well, you can't because it's your investigation, but then don't ask for the help. Don't get people involved and emotional about it and then say, sorry. It's like, dangling that carrot in front of the, the horse and letting it run after it forever. That's where we're at. And now when it's actually time for us to be able to get all of those answers as the public who is emotionally invested, we now have a judge who won't allow it. And so even people who are like, in the middle of whether they believe Richard Allen is guilty, those of us that kind of still sit on the fence waiting for the evidence to kind of say what is what do? We just, we don't have trust in the system because of the 7 years of bullshit. I don't know. I don't think there's much that can be done for it to be stopped. It's like, what I'll say it's like watching that damn ship headed towards that bridge, knowing that it's going to collide, and you can't stop it. You know, you guys saw that the barge that ran into the bridge this last week, and just the bridge just crumbled. So it's like, you know that the bridge is going down, but you can't stop it. All you can do is watch it go down and then prepare to rebuild it. That's all you can do. And as attorneys, that's what they're doing. And so people are like, they're desperate, they're this, they're that. They're not. What they're doing is setting up the ability to rebuild the bridge via appeal. That's what they're doing. The Chicken Nugget says they're just going to come out with the PCA evidence. Yeah, I give us just something that's undoubtedly legit. And if you got it, then just put it out for the world to see. Not like, you don't have to right now. I get that. I get that there's, they want to keep some of the things for trial, but now you're going to hide the trial, and then you think that the world isn't going to go, what the hell's wrong with this? Because we're going to go, something's wrong with this. Great analogy. I love analogies. That's how I feel about it at this point. To have a stenographer take notes in court for every day of this trial, that looks like the only reliable. I don't know if she would allow a stenographer in there. I mean, we won't even have the reporters who are able to go in there and like live tweet. We won't have that. I mean, there's the level of I don't know if intransparency is the right word, of non-transparency is at like an all-time high right now. So I don't know. People want to have faith in the justice system, and I get that there's people who out there who absolutely trust that Judge Gull is doing the right thing, and there's people who think that McClelland is, amazing and he's totally ready and he's got this. If that's the case, then why can't we watch it? Why don't we get to see it? Well, that's just because Gull has the right to do that. Yeah, she does. You're right. It doesn't make sense though, does it? I'm still not convinced there will be a need for an appeal. Juries can be smarter than we give them credit for, and will hopefully see through the BS. A shorthand person, she can't deny she wouldn't know. Correct. They could do that. I just don't know if she'd let a stenographer in there. No sketch artist allowed. Well, I mean, if you have somebody who happens to just know how to draw, and they, or sketch, and they happen to get in the courtroom, but that's the other thing, is like, there's no mandated, like, this person will be here every day. So even if they do have a shorthand person, that person's not like, I don't know if they would be, I don't know if Indiana does a lot of things when it comes to media. People who've been at the hearings, have you guys seen people with press passes get any type of like early entry or anything like that? Because I don't know if Indiana does that. Some states do, some states don't. Yeah, hiding the incompetence. Well, this is what I keep going back to, is I'm not necessarily of the belief that there's like a grand conspiracy of covering up, this law enforcement's, and I know people believe it, so I mean it's fine. I don't mean to bash it by calling it like a grand conspiracy, but this is not where I'm at. I'm not quite there of that, like, law enforcement was involved in the murders and that's what they're covering up. I'm more at, I believe that all the shenanigans that we see are in order to cover up all the bullshit that they've done and the crap they've done wrong for 7 years. The state goes and eats their sandwiches. Yeah, I mean, that's a good point too. But, they may have something that we don't know, some type of ace in their pocket that we just don't know about. My current thought process is there's something in the geofencing that's either going to help prove he's the right guy or it's going to help exonerate him. That's where I'm at with how I feel about all the other things. He was opting for a plea deal, but I do think those bastards with Ellie hid stuff from him in the very beginning too. I think so. I don't think that he's out there just blatantly like, oh yeah, we don't have any idea who the professor is. I think that Holman's like, shit. Sorry, I'm just trying to catch up on chat. How the hearing would go down, and he was exactly right. But he also knew the importance of getting the information out as well. Yeah. Totally agree. A mishandled investigation is now being factually exposed. That's where I'm at with it. I think that they don't want us to see that. Gull plays crossword puzzles on her phone during case or one of those games people play on their phones to kill time. She just seems bored. I heard from the last hearing that her interest seemed the most piqued during Todd Click's testimony. I wasn't there, but that's what I was told by a couple different people. So, hey Lambert, it would be hard for her to face the people day by day as she condemns RA with no proof. If what she is ready to do were public day by day, the public may stand up and tell the news worldwide the truth. True. I'm not set on the guilty or not guilty. When I'm set on as a fair trial. In 25 years of trial watching, I've never seen anything like this. Michelle, like, literally, you and I are on the same page. And then people are like, get off the fence. I'm like, I can't yet. I can't get off the fence. I do Tetris. Go plays June's Journey. Oh, Jesus. Speaking of June's Journey, I'll play you guys another clip from the news that I found quite interesting, and that's going to lead us into part of the next topic. Actually, I might wait to play that. We should maybe I'll do the motions first. Let me see. Actually, no, I'll probably wait. Travis, are you ready to come up now, or do you want to come up later? Because Travis is going to come and talk us through something to do with the attorney that is now filed for appearance, and they're asking for funding for her. So let me just get the motions up so I at least have them. I can come on now. Okay, we'll do that first, and then I'll play you guys the other clip, and then we'll talk about Hennessy. Okay, so let me get the motions up. So first things first, while he's coming on and joining, the beginning of this week, last week, I don't remember anymore. We talked about the amended motion to compel and request for sanctions. And I told you guys there was still going to be the back and forth until the judge made her ruling, and she did. So she did make the ruling and stated, the court, having taken defendant's amended motion to compel and request for sanctions under advisement, and having reviewed the state's response filed March 23rd, 2024, now denies the defendant's amended motion to compel and request for sanctions without hearing. So, essentially, whatever the response was that we had gone over is now good enough for Gull. There's Mr. Travis. Hi, Travis.
Hey there.
Thank you for coming on. I know, Good Friday.
Yeah, thanks for having me. Good Friday for those who celebrate. Otherwise, thank God it's Friday for those who believe.
I think it's TGIF for anybody at this point.
Yeah. I sent you the latest marked up version of that motion regarding the public funds. Is that the one you wanted to go over, or another one?
Yes. Yes. So this one right here, I just wanted to I just touched on the one that she denied for the motion to compel. And so I just pulled up the limited appearance, and then we can go over the funding.
Okay. I have a marked up one of that I sent to your messenger. If it's too much trouble to bring up.
Now.
Okay.
Nope. Getting it right now. Downloading it currently. Here we go.
You have any plans for Easter? There we go. Okay. Perfect.
Oh, that's too big. Here we go. And thank you for coming on and going through this with us, because this, sometimes when they throw out these random things like this Tory motion or filing, that's what they're asking for her to come and help with. We get like, what is that? So I appreciate you coming on and helping to break it down.
Yeah, because there's a lot of things that are intertwined in this that I put at the end, kind of a laundry list that we can cover one or more of them that you find interesting. But so you want to remind everybody essentially what this motion was for, or do you want me to do it?
I can do it. That's fine. So a couple days ago, the defense has requested for a limited appearance on behalf of the defendant, Richard Allen. They're asking that for a limited capacity in the case for the defendant, Richard Allen, this filing is intended as a limited appearance with the understanding that counsel will be assisting the client, Richard Allen, and attorneys Andrew Baldwin and Bradley Rosie with matters related to the service of process and future depositions of Federal Bureau of Investigation agents associated with the investigation and the prosecution of Richard M. Allen. Counsel further anticipates assisting defendant Allen and his legal team with digital forensic issues surrounding the investigation and prosecution of defendant Allen, including but not limited to conducting discovery, depositions, and courtroom examinations regarding the same. So the attorney that they're asking to bring on is Jennifer Auger, which I do have a little bit of information on her too, but in doing so and asking for them to be able to bring on Jennifer Auger, they are also requesting the court, being Judge Gull, to pay her for her services. Now, with everything that we know about Judge Gull approving payment on stuff, which will lead us right into the next topic after we're done going over this motion, she doesn't really like to approve a lot of payments for the defense. So here we go. Okay. Do you want me to read it and then you'll start, or you want to just go through your highlighted points? Hi, Bob.
No, you can kind of, why don't you read through it? And then when I say pause, we'll cover, and we'll probably pause at the red boxes or the most significant stuff. But do you have the info that you got on Attorney Auger handy? Or what did you find out about her?
So here's her background.
Great.
So I don't know if you guys can see that. Let me see. Let me get that blown up a little bit more. So here's her background. She graduated from Indiana University in 1993. She attended Emory University College of Law, top 25 law schools, where she graduated in 96. Following graduation, she was admitted to the bar in Georgia, the Commonwealth of Virginia, and in the state of Indiana. She was admitted to practice in the federal courts of the Southern District of Indiana and the Eastern District of Virginia. She began her career as a lawyer working at DeKalb County Public Defender's Office in Atlanta. Jennifer had not guilty verdicts in robbery, burglary, rape, and theft cases in Georgia. In 97, Jennifer went to work in the personal injury section of the Mitchie Hamlet Lowry Rasmussen and Tweel, a leading Virginia law firm located in Charlottesville. Jennifer was a member of the trial team in the case of Tommy Horror versus Great Eastern Resort Management and won, at the time, the largest ski verdict in Virginia history. And Jennifer led the appeal, which resulted in upholding the $6.2 million verdict. So that's just a little bit about her.
Okay, good. I'm glad we did that. So yeah, why don't you start with this motion, and we'll tie a bunch of different things in here.
Sounds good. Okay, so comes now Brad Rosie and respectfully requests that this court authorize the expenditure of public funds to reimburse attorney Jennifer Auger for legal services rendered on behalf of pauper defendant Richard M. Allen. In support of said petition, attorney Rosie swears and affirms as follows. Number 1, defendant Allen, having been previously determined to be indigent, is currently represented by public defenders Brad Rosie and Andrew Baldwin. Number 2, a speedy trial is currently scheduled to commence in this matter on May 13th of 2024. Number 3, the volume of discovery and evidence that exists in this case is unprecedented and has been articulated in various defense pleadings previously filed with this court, of which defendant Allen incorporates herein by reference. Number 4, one small but extremely important part of the prosecution's case and of Richard Allen's defense is the existence of digital forensic information, including but not limited to information obtained from the victim, Libby German's cell phone, as well as information extracted from a cell phone tower near the crime scene.
Nothing to add there. Your audience is all aware of that. You've covered geofencing and everything. I just circled that because that's the heart of it. Keep going.
Mm-hmm. Okay. Number 5. Over the past several weeks and through the vehicle of discovery depositions, the defense has attempted to identify the state's witness and or witnesses regarding the digital forensic information obtained during the investigation. The process has involved some trial and error, but the defense now has reason to believe the state's witnesses regarding the digital forensic information are agents of the Federal Bureau of Investigation or task forces associated therewith.
Okay, so people have been asking in chat, yours and Bob's, what's required to get a hold of a federal agent. And it's not as easy as a lot of people think. It's you have to make a request. It's called a TUI request. So to get a federal agent, FBI agent or otherwise, to testify in a state court proceeding, you have to get the permission of the FBI. They're immune from state civil process of service. A federal agent doesn't have to obey a state subpoena. There's a lot of historical reasons for that. We won't get into unless somebody's interested in it later. But so federal task force officers, federal agents, that's what they're talking about in the request. They mention she's familiar with the TUI process. And if you're not familiar with it, it was kind of daunting the first time I had to get federal agents in a state case. And, you kind of go through it a few times. The key thing is the contacts, having the contacts, knowing who the general counsel for the FBI is, who the U.S. attorney is in that district, and then, the various people that within the government that deal with that stuff. And the first time, if you don't have those contacts, it's like anything else with government, calling the IRS or Social Security or any federal agency, you could get a runaround for days until you get to the right person. And then generally speaking, at least on the legal side of things, general counsel offices for the FBI, U.S. attorney offices, generally when you get to the right person, things flow very, very quickly from there. But surprisingly enough, most attorneys that have a state court practice in criminal defense or civil litigation, you just don't come into it very often where you need to subpoena, the defense needs to subpoena or arrange for the deposition of a federal officer. Normally, it's the state who's sent something to the FBI crime lab in Quantico. And when the FBI is cooperating and working with the prosecutor, they just pick up the phone. They don't have to go through anybody, but it's because the FBI is cooperating and on board with it. And from the defense side, to get them to come out, be able to depose them ahead of time pursuant to state law, all those things, it's quite an ordeal and it's time consuming. So that's what the federal agents thing's about. I made a note at the very top, not ex parte like the other ones have been. And then I have a note there you can read with some thoughts I had about it.
Okay, so just to clarify then, if the state was using the federal agents to testify, and it would not be an issue then for the defense to be able to get a hold of them and talk to them. Is that correct? Am I understanding that correctly?
No, it would be. So let me make it really clear. And I don't have an analogy like a ship sailing into a bridge. I wish I did. And I'm really pissed off at you. You came up with that before I did, because that's one of the best analogies I've heard all year. Anyway, so
Thanks.
If this was a ballistics expert or tool mark expert that examined the unspent cartridge, prepared a report, and was willing to come and testify in the case, the state would have no problem doing that because the FBI is on board with it. And FBI lab people testify in state court actions all the time, every day, all day, in any given state. If the defense wants to either talk to an FBI agent, depose an FBI agent to find out what they're going to say at trial in states that allow depositions in criminal cases like Indiana, or to subpoena a federal agent to trial, they have to go through this process. The state doesn't if the federal agent's on board and they're going to call them. So if the state's going to call a federal agent and that federal agent is on board, his agency has approved it, they're part of like a joint federal task force, which has state and federal agents as part of it. It's no problem for the state because that agency that the federal agent works for is on board with it. But the defense always has to go through this process. And
Whether the agent is testifying for the state or not, this still has to happen for the defense to be able to depose them or call them as a witness.
correct.
Okay.
And
So
if the state's going to call them as a witness, you don't need to worry about it unless you want to depose them first. Then you got to worry about it. You got to go through the process to set up the deposition. In other words, a lot of those witnesses that were deposed on March 1st, like Holman, for example, whoever was going to depose it, I can't remember if it was part of the contempt. Hennessy's office called up the DA and said, "Look, we want Holman's depo in preparation for the contempt hearing. Will you produce him?" And normally they will, because in terms of scheduling, they can work things out, and it's mutually beneficial time. Whereas if the DA refuses and they just served Holman with a subpoena, said, we don't care if you're going on vacation. We tried to work it out with the DA. They wouldn't. You need to be in our office when we say, and that's so generally it gets worked out. But they can't call up and say, "Mr. DA, you've listed federal agent Joe Smith, who handled the geolocation. You've named him as a witness. We want to depose him." Well, we don't have any control over him, just like we wouldn't have any control over some civilian that we've listed as a witness. We can't accept process for them. You're going to have to do it in the normal course. And that's true. They have no control over a federal agent, FBI or otherwise. Okay, do you have a number? Yeah, here you go. And you call up that FBI agent and they'll say, "I can't talk to you. I can't accept service. You need to submit a TUI request." And everybody knows that's ever had to get a hold of a federal agent to either depose them or subpoena them for trial what a TUI request is.
Okay. It makes worse. Okay, let me go to your note here. Okay, so by not filing this motion ex parte, it automatically goes into the electronic filing system and is public in terms of who can access it and get copies of it. So it appears that the defense is taking their plight to the public on two fronts. This public request for funds for an attorney to set up the deposition of current or former federal agents via the TUI requests. The second way is Lead Pipe's crowdsourcing for funds for experts. The crowdsourcing has gotten traction in local print and broadcast media all over Indiana, including stations in Indianapolis. Lead Pipe has provided background information and was quoted in at least one station's coverage. is he under a gag order? Is this what are you asking here, or you want to talk
Yeah,
about that?
just kind of throwing that out. Let's talk about that at the end.
Okay. It appears that defense counsel was unaware of the requirements for depositions, interviews of federal agents, and obtaining their records, which is not uncommon. Okay.
And we covered that. So if you can go through 6 and 7.
Okay. So the defense has attempted to order up the depositions of certain FBI agents that appear to be part of this investigation. Said discovery attempts have been burdened by the necessity of satisfying the TUI process, which requires the submission of documentation and pre-approval by the FBI in order to simply sit down and take a simple deposition of any particular agent.
Okay, so
There are all
reading between the lines, can you kind of sense the frustration there, or is that just me?
Oh yeah, like they can't even just sit down and depose these people like they can to anybody else.
And you kind of get the sense that they weren't really aware of what the TUI process was, but that's not unusual. I'm not faulting them at all. I mean, you could go an entire career doing criminal defense in a state and never ever have to get a hold of a federal agent.
I also feel like there's some frustration in the fact that this just came out in the last response from the state on the motion to compel, that the 2 people that worked on the geofencing were actually FBI CAS team members. That wasn't released information prior to that to the defense team. So they didn't even know who worked on it.
Yeah, and what might even be more frustrating is what I have in that blue note there. So there's all kinds of task force. There's usually a fugitive task force, which are comprised of U.S. Marshals and then other local law enforcement. They go and find these people that have warrants out for them, state or federal, and really bad people. And, they have all kinds of way of tracking them down. There's usually a federal bank robbery task force. I don't know what this task force was that they're talking about. If there was I guess there was a specific Delphi task force that included, at least at one time, federal agents. Is that right?
That's my understanding of it, but we were never really given the amount of information on who was part of it, and I don't think this is inclusive of the same task force of like Murphy, Ferenczi, but I don't know. I'm being told that it was somebody with the last name Abbott that was also one of the agents that was involved, but I don't know that information myself. So
yeah, so they're mentioning at the top of 6, order up the depositions of certain FBI agents that appear to be part of the investigation. And yeah, you have to go through the TUI process. I don't care who you are, what the case is. Agents aren't allowed to talk to a defense attorney or agree to attend a deposition, without being approved by the general counsel of the FBI or the U.S. Attorney's Office for that state. So yeah, I sense frustration. Why can't we just simply sit down and take a deposition? Once they get to the right person, it does become that simple, but you got to get to the right person. And then the other thing, it doesn't look like there was a federal task force, but if there was a federal task force set up for Delphi, it would include federal agents and state and local agents, most likely. The state and local agents on that task force are considered federal agents. I don't think that applies here. I think these are clearly FBI agents. They did mention a task force, but I put a little note there in blue that even though a state police, Indiana State Police, goes and works for the federal agent, if he prepared geofencing, for example, as part of a federal task force, you got to do a TUI request. The reason I know this, go ahead.
I was going to say that's a question I had then, because technically the people in charge of doing the geofencing is the cellular analysis, whatever. I think it's, I don't remember the S now. Survey? Somebody correct me if I'm wrong. Team. So would they be just considered a task force on their own? I mean, so that might be why they're calling it a task force.
It has federal task force, like the fugitive task force with the U.S. Marshal's office, the bank robbery task force in an area with the FBI, drug task force by the DEA. There's lots of agreements and paperwork involved with those. They're not ad hoc committees or task force. They're very well established. Who's in charge, whose policies and procedures and rules of engagement with the use of deadly force, for example, is going to apply. And who, that if they're borrowed from a local police department, like the Indianapolis Police Department, for example, if there's conflicts in the policies and procedures between the federal agency, which usually is going to be FBI, and the local police department. For example, if the FBI said you can use chokeholds, they don't. But if it did, and Indianapolis PD, I can guarantee you now, says, no chokeholds, which one's going to take precedence? I mean, it's very detailed, and then state and local police that become part of a federal task force, they're formally deputized as federal agents. They know it, and they're issued federal identification, and they're issued federal badges. They mentioned task force in here. I suspect that they're federal agents that maybe went on a state task force, and then they're only federal officers by virtue of the fact that they're actually federal officers, like FBI agents. The fact that an FBI agent works on a state task force doesn't make the state task force federal.
Okay. But if they're working on the FBI one, it makes them federal.
If there was one created, which there may have been one, like, because it involved kidnapping or something, but just from listening to your presentations over the last several months, and Bob's, which is, and a couple of others that I tune into, I'm not real up on all of the facts before, the October 19th debacle. I think that's when I first started listening in, is about a few days before that. I don't know all of the things that you and Bob and others talk about on your presentations about all of these facts and where they came from and all of that stuff, because there wasn't a lot other than I think a motion in limine regarding the tool mark expert last August. That was really about it. But y'all know way more about FBI agents. I've heard you mention FBI agents well before this. I know about this unified command thing. From what it sounds like to me, it's they're running into this brick wall for now by trying to take depositions of the federal agents. They've narrowed it down that it's FBI agents according to this motion that were involved in the geofencing or other digital data and whatnot. They've tried to set up their depositions and hit a brick wall, and they need to get Attorney Auger involved because she has experience with TUI requests. And it's a time suck out. It's a huge suck out you can spend hours and hours and hours just trying to set up depositions. It doesn't get you anywhere in terms of trial preparation.
So that was going to be my question, is now that they want to depose these FBI agents, what does this do to the timeline of trial?
It doesn't do anything to the timeline. That's totally up to them. They're just asking for money for a lawyer to get going on it and moving it forward. I think what's more telling is that they've made the request in public. I think Lead Pipe was on with Bob earlier today talking about the crowdsourcing for the experts, along with another creator I'm not familiar with. Please forgive me.
It's Unsolved Crimes Uncovered. Yes, we're gonna go over that after we're done with the motions anyway.
Yeah. So just as part of that, he was mentioning that they were going to need an expert in geofencing, but he mentioned, I'm getting ready to submit a bill to Judge Gull. He said, I've got about 500 hours on this contempt thing. He goes, I know she won't pay it. I'm just filing it to watch her head explode. I think was his exact words, which tells you why I've dubbed him Lead Pipe. That's what lead pipes do. Lead pipes let people know, but we'll talk more about Hennessy later on. But his whole career has been devoted. This ain't his first go around trying to get fairness for other defense attorneys. He's one of the founding board members of the Indiana Public Defender Council, not the commission, the council, right, which purpose is to educate public defenders, especially newer, less experienced ones, and provide them with certain types of financial assistance. They get grants from the state and the Indiana Supreme Court to educate lawyers that handle public defender cases, pauper cases, they call them there, and to get some sort of financial assistance, whether it's for training or whatnot. But he's been on that council since its inception and has been, an officer and remains a board member for decades. But that's right, what lead pipes do. Even though they may take 95% retained, which is paid, they may not do hardly any, if any at all, public defender pauper cases. They, people who do criminal defense work, the serious trial lawyers, the serious lead pipes, it's ingrained in them. And when you hear Bob speak, you hear Allie speak, it goes down into their soul, into their bone, to their, who they are. Yeah, to their marrow. And so you frequently see attorneys like Lead Pipe paying it forward, paying it back in ways like these. And so just hear him say he's going to file that bill. But, I don't know. To me, I don't think they know they're not going to get this. That's why they didn't file it ex parte. Even if they filed stuff ex parte, it seems it gets to the other side where they can read them, even if they're not supposed to. So it's like, well, it's not like we're giving anything away. Let's just file it publicly. Right. But let's keep going. No answer some of the questions at the end.
Okay. So where are we at? Okay, so there also exists the burden of the passage of time, which naturally has created scenarios where those involved in the investigation are no longer employed at their former location or in their former capacities. All of this is the cause of logistical delays. And then we went over your note, correct?
Yeah, we did. Okay, going. Yeah.
Number 7 is attorneys Rosie and Baldwin have very limited time and therefore need assistance with this process in the process of vetting the digital forensic evidence involved in this investigation. Attorney Rosie and Attorney Baldwin have sought out the services of Attorney Jennifer Auger, who practices in Franklin, Indiana, near Attorney Baldwin's office, where she would have easy access to the pertinent discovery in this case. Attorney Auger simultaneously herewith has entered her limited appearance in this cause. Okay, I think the mods will take care of it. They'll take care of it. Okay, number 10. So attorneys Rosie and Baldwin believe that it is that it is in the best interest of defendant Allen and in the interest of judicial economy that Attorney Auger assist defendant Allen and Rosie and Baldwin by addressing the circumstances surrounding the digital forensics in this case, and therein request that this court order the Carroll County auditor to reimburse Attorney Auger for costs associated with her services at the same hourly rate as that which attorneys Baldwin and Rosie are currently being compensated. Said reimbursement would be contingent, oh my gosh, I can't speak today, contingent upon the court's pre-approval of Attorney Auger's submitted invoices and rate same, approval same, which they don't necessarily get approved, but it is what it is. Defendant Allen has been consulted and consents to the entry of Attorney Auger's limited appearance in this cause and for the purposes referenced herein. Client's consent. Okay, I know you said you have notes down here, so we can go through here too.
Yeah, kind of the next page, 1 through 9.
Right.
So you can pick out any of those you think are interesting. We've already covered number 1, I think.
So I do have a question. So she has to approve, obviously, for this attorney to come on and get paid. So that's what the motion is for. But my question is the Turi process, if there's a request for them to be able to depose an FBI agent, that goes directly through the agency, right? That doesn't have anything to do with Judge Gull's court. She's not approving for them to talk to the FBI, correct?
No. She's just, they're saying we got to go through this TUI business. We don't have time, given the late date that we became aware of it with all the, we got to get ready for trial. We're 50 something days out or less, and we don't have time to be doing TUI requests and tracking stuff down because of the late notice of these FBI agents. So we want all that attorney is going to do is, from this motion, the way I read it, is track them down, arrange for their proper service for a deposition, and potentially trial. I don't even get the notion that she's going to be taking their depositions. That's going to be for somebody else, but just taking care of this administrative stuff, which it looks like Gull authorized 15 an hour for an experienced legal assistant paralegal. I think I read somewhere Gull only approved 15 an hour for that person. So they're making it clear, we got to have a lawyer do this same rate that you're paying us, which is can't believe how minuscule they're paying them for this level of case. I dug up what they pay in Illinois and what they pay in Wisconsin, the neighboring states. It's 1.5 minimum higher what they would pay attorneys for this level of case. But it is what it is. And so, they want 100 an hour. They're not going to get anywhere paying somebody 15 an hour trying to do TUI requests, is the way I read that. Okay.
Well, and he's already capped out. So the Unraveling was kind enough to put this together and posted it earlier. So I grabbed it from them. So yeah, Matt Hoffman, who was the is the investigator for I was going to say Hennessy, but it's not Hennessy, for Baldwin, was given $15 an hour with a $6,000 cap. So essentially 10 40-hour work weeks. Anything past that has been denied, which, I mean, 10 weeks of 40 hours a week, we know he's way past that at this point. So he's essentially just not getting paid anymore from the court. And then they total out. We can go over that too when we go to the other stuff. But to bring up he's essentially working and not getting paid.
Okay, so that's actually a licensed private investigator. She's paying $15 an hour.
Mm-hmm. Yeah, but with a $6K cap, so it's already done. Yeah.
Well, the initial caps are kind of common, and you do need to watch some investigators. I mean, they'll follow every lead, and sometimes they get they're afraid to ignore something, and you have to. And so the court will say, "Yeah, I'll give you a private investigator initially, $2,500, and then and then they'll keep giving you more, but they like to track it." But that's a travesty right there. I mean, I think our lowest rate for, I don't do much, if any, appointed work anymore, what they would call public defender work there. I think 10 years ago, our rate was $55 an hour, and $65 if they were bilingual. I mean, that's just atrocious. $15 an hour. Well,
yeah.
In Austin and surrounding area, pretty much anywhere in Texas, I mean, you start at McDonald's at $20 an hour. I mean,
I was just gonna say out here, yeah, McDonald's workers are making 19 to 20 starting. Yeah,
I see that all over. Newport Beach, for example, and all over Orange County. There's signs everywhere. Carl's Jr.'s, we start at 20 or whatever. Anyway, so
just another example of somebody who's doing this now essentially for chump change. And even if he's now currently being paid out of Baldwin's pocket, it's still chump change, and he's doing it because he believes in the process. He believes in what they're doing. So, okay, so let's go through request for funds.
Yeah. So I just threw some stuff up for consideration. So I put kind of one question. Some of these are rhetorical. So this is a motion to the court by defense counsel for funds. Can the state respond? And, not normally. Normally, it's not any of their business in terms of funding or whatnot. And so even if they could, should they? And, probably not, number one, because that's what they're going to get back, is that it's none of their business. And, it's between under Indiana system, it's between the public defenders and the court, with the court having the final say on what they're going to approve in terms of expenses.
So what I'm hearing you say is that we should expect a response from Nick?
No, I would doubt it.
I'm just kidding. I'm just kidding.
Yeah,
okay,
I would doubt it.
You gotta go real quick?
No.
Okay.
Nope, I'm all good. Had the window cleaners here today all day at the house. We have something like thousands of square feet of glass, inside and outside. So anyway, they were just telling me they were all done. Sorry about that. Anyway, no, I would not expect a state response because it's not their business. And normally it's done ex parte and they don't get to see any of it. Apparently, Nick is the only former public defender in the history of Indiana criminal defense work didn't know you're not supposed to read an ex parte motion for experts, but be that as it may, hopefully he'll know it, he doesn't have what we call, when we say it's none of his business, he doesn't have standing to say anything about it. So I don't think he can say anything, and he shouldn't. He should stay the hell away from it, because
you keep saying that makes me feel like we're going to see a response.
Well, looking at it that way, and I trust your premonitions and your hunches and your knowledge of human nature a great deal, and so yeah, maybe we will. And I guess the better question is she going to issue a public order on it in light of number 3 and number 4? When I wrote this up around Tuesday, it had just been announced, the crowdsourcing platform, and then it had everybody covered it, and some got input from Hennessy, one of the outlets, TV station in Indianapolis, talked to the executive director of the public defender council, and that executive director explained this dilemma that defense attorneys that are being paid by the hour have versus a larger city like in Fort Wayne, Allen County. They have their own private war chest. They budget and request money for experts, and you don't need to go to the judge for approval. You just go to the head public defender, and they're going to be budget conscious too. They can't blow, if they get $100,000 from the state for the entire year, or the county, they obviously cannot be doling out funds to private public defenders and blow the whole budget. And so, they're all conscious about it, and not letting anybody go crazy, but you're not having to go to the judge that's deciding the case to figure out what you're going to be paid on experts or not. And the whole thing's just baffling just on the tool mark evidence. Okay, so some people call it ballistics, but trust me, if you've ever cross-examined a forensic ballistics expert or a forensic tool marks expert, they're going to let you know pretty damn quick that markings on cartridges are tool marks, and markings, lands, and grooves on lead bullets is ballistics. They get offended. So it's tool marks. But that, from all appearances, was a huge, huge piece of this case, like DNA in a lot of cases. And we knew from the hearing on the 18th, Monday, that she made the defense attorneys front it, and then they asked for more, and she denied it. And is that because? And they're saying because a one-liner, wasn't even in proper form. Not enough information. It's just total fucking bullshit.
Tell me how you really
feel. Total bullshit. It's like saying, they find one piece of a detonator, 1 inch by 1 inch square. That's the biggest piece they can find out of a bomb that blows up a federal building in Oklahoma. And, they get a readable print off of that detonator. There's no judge in the world that within reason, and 6,000 for a tool marks expert or whatever they'd already approved, I mean, is nothing. Wonder what they paid that guy from Louisiana, the firearms expert who testified in Reed. I bet his bill was with the trial was 25,000. I mean, it's just, it's just completely ludicrous, 6,000. But anyway, who knows? Obviously that person is critically important. That's why I gave. I knew it was going to cost double, triple that. And if you don't have a tool mark expert, you might as well just pack up and go home. I mean, it's game over. So not really sure what's going on with her on that, but maybe his rate's too high, doubtful. She wants some sort of a budget. Then, she should specify, look, I need more information. How much more time does he anticipate prior to trial? And then basically it's what's called their rate card. And, in federal practice, all of this stuff has to be prepared. The experts have it. You ask, what's their rate card? It has to be sent to the other side, what their travel rate is. And, they all have a travel rate. Testimony, it's usually for a full day, whether they testify for 15 minutes or 7.5 hours. Some will break that down into a half a day. And then most will go along with whatever the judge says. Look, I'm only going to pay for actual travel time. I'm not going to pay a per diem rate based on the normal rate at 8 hours. But I haven't seen that in a long, long time that they want anything more than their actual travel time. So I don't know, the stuff that's coming out, I've never, ever seen that. And I've been involved in raising money for other defense counsel for this exact same thing, which is, I was a little perplexed by some of the comments leading into it. It was during one of your lives. I said, we need to raise money for experts. And then you kind of hear the normal stuff. Well, you can't use a GoFundMe to raise money. And I'm like, you don't need a GoFundMe. You don't even need a crowdsource, frankly. I helped one of my clients. She put in 6 figures, and we helped get another low 6 figures for a case in post-conviction. It was before Facebook, any of this stuff ever existed. We did it all by email campaigns. Ideally you have somebody one step removed from the defense attorneys. Hennessy, I didn't know he was willing to step up. That's awesome because of his involvement with the council, and so it makes it one step removed, or a board of directors of 2 or 3 defense attorneys in that area, and you count for every dime. You marshal the limited funds you have as best as you possibly can without interfering with the defense attorneys, and you go forward. But it's no problem. And I'm really proud of, for lack of a better word, but proud of your audience, Bob's audience, the community, so to speak. And, it's pretty impressive to have half the amount raised in 24 hours, and we're over the amount now and climbing, within, on the end of the 5th business day, it happens to be Good Friday. I don't know if there's anything to read into that or not, but whatever. But, it's, there are huge concerns. And this doesn't even cover that they're not getting paid. And I just, somebody mentioned, been watching, before I came on in the chat, I've been watching, somebody said, been watching trials for 25 years, never seen anything like this. I've been practicing, this is my 40th year. I've never seen anything like this. And, I've been around stuff like the Michael Morton case, the Waco, where they tried all the people that survived the Waco fire and all of that. I mean, been involved in either directly or tangentially to these cases, and never seen anything like it, except Yogurt Shop in Austin that has some similarity. That there was a delay and a lot of pressure on law enforcement. West Memphis 3, a lot of pressure on law enforcement. Plus you had allegations of real serious ass corruption in West Memphis 3. Drug evidence missing. They were being investigated by the state police, but this seems to be a very common theme when cases run cold for a while. West Memphis 3 was just about a month, but this for years, and then all of a sudden it pops, there's a break, so to speak, and it's very, very common to see problems, and the only way to avoid them is either an experienced prosecutor that knows better than to mix politics up in it, or a judge that's keeping it fair on both sides. And if you don't have that, you basically have a mob, and it's no different than trial by ordeal or trial by combat, which is what we had before jury trial.
So is there anything she can do to stop the defense from using this fund?
No.
Okay.
I'd like to see her try. I mean, Lead Pipe and the Princess of fucking Darkness and Kara would have a field day with that. I mean,
that's what I figured.
They'd probably have a line of volunteer. I mean, crowdfunding, I think I mentioned it here. I mean, it was when I was, let's see, that would have been, I'm aging myself here, in the 70s. My dad told me about this woman who'd been arrested, held in jail. She was a college professor, and her nephew, I believe it was, ended up using a gun in a murder of a judge in Marin County. And he said, I said, well, she didn't know? And he said, well, they're saying she did know, that she gave it to him and helped plan the murder. And she's entitled to a public defender, but it's just way too big for any public defender to take. And so they're raising money, and he said, I'm going to contribute this. Do you want to contribute some money? And So I did something, my paper route or something, and I contributed like $25 to her thing. We went down to a cook-off or something in the Bay Area where we were living at the time. That was Angela Davis, who was ultimately acquitted, and she had a lead pipe attorney, but they raised money for her. Now she was a dyed-in-the-wool communist at UCLA, and then up at University of California, Santa Cruz, the Slugs. Anyway, she is just not real popular, but at that time, they raised a bunch of money for her, hundreds of thousands of dollars, hundreds of thousands for experts in West Memphis 3, kicked off by celebrities, but a lot of grassroots people, just like this thing. There are all kinds of fundraising where the attorneys may be getting paid by the state, but other necessary needs are being taken care of for the family of the person that's in prison, for expert costs, for a lot of different things. But it's been done for decades and decades, and as long as you do it above board and ethically, there's absolutely no problem with it. So that's why they were very careful.
Go ahead. Sorry.
You go ahead.
Is there a way that she could, and this kind of goes to BH's question and Mustang Driver's comment, could she improperly disqualify the experts or do something to make it so that those particular experts can't testify?
So with experts, as Bob's mentioned a few times, so normally we have this standard and there are Supreme Court cases, but Daubert versus Merrill Dow Chemical, for example, is the big federal one that adopted by U.S. Supreme Court, adopted in Texas. Before that, we had the Frye standard, FRYE, that basically was addressing junk science, forensics, how a judge should be the gatekeeper on something that's supposed to be hard forensic science, expert testimony that doesn't involve science, when it should be allowed, how it should be allowed, and it's pretty straightforward in Texas. The stateless experts were entitled to what's called a gatekeeper hearing. It's the one thing in Texas we have to let the other side, the state, we have to give notice of our expert 20 days before trial. It's the only thing we're required to give. We don't have reciprocal discovery like Indiana does. And then typically we ask the trial court for a hearing to have the state bring in their experts, and then we put them on the stand, ask what their opinions are, what did they base their opinions on, what articles they find authoritative, what textbooks and treatises they find authoritative, kind of nail it all down. And then if we have a serious concern about the validity of the science or the validity of the way the testing was done or the machines, instruments that perform the testing, we have serious questions about any of that, we can either challenge the results and ask the court for a pretrial ruling, or challenge the qualifications of the expert, or challenge the qualification of the the science. For example, bite marks, for example, or trying to use hair comparisons to make a definitive match. Those things largely completely debunked, and many exonerations. And so those things you wouldn't have a fight with in Texas, but some states still believe in bite mark, and I don't think anyone still uses hair comparisons and to say that they're a match. That a hair found on the decedent matches, no DNA, matches a hair sample from the suspect or the defendant. So, but Indiana hasn't officially adopted Daubert, Daubert. Some pronounce it Daubert, but Daubert. They say it's well, we don't officially adopt the holding of Daubert. It's guidance for judges to look at. So it's guidance. So as Bob says, we don't know what the hell they do there. So to answer the question, I didn't catch the name of the person that posted it. It's an excellent question. It's always up to the judge to determine whether they're going to allow an expert. But
That was BH's question.
some things are just, so if the state comes up with DNA evidence, you're going to have an expert explain it, get the result in, assuming that the folks that are hired are qualified. And there's no doubt in my mind that Baldwin, Rozzi, and with Hennessy's approval, are going to have highly qualified experts. So if you have a DNA expert from the state, they're going to be able to counter it with a DNA expert. Tool mark evidence that the unspent shell casing cartridge came from a gun in the possession or owned by the defendant, the defense is going to get a tool mark expert. To deny that, absent qualification issue, which is not going to be, to deny that testimony would be reversible error. Now, let's say they've asked for some experts to talk about the conditions under which he was kept being potentially conducive to giving a false confession. Now, that's what we call a soft science, psychology, sociology. There's no test that will tell you under a microscope certain marks. There's no similar test as to whether you're more susceptible. So it's referred to as a soft science, and the judge has a lot more latitude on what they can allow or disallow on something like that. Now, today, what caused me a little bit of concern is that during the Live with Bob and Lead Pipe mentioned that the state had, contrary to, so the state had a DNA expert, a blood spatter expert. I think those were the two that we didn't know for sure, but also that when I saw what had been paid for earlier in the week, I made the comment that, so the defense hasn't asked for a DNA expert up to this point, and multiple people confused that. And I said, well, that must mean there's no DNA that relates to Richard Allen. Otherwise, they would have asked for a DNA expert probably before they asked for the tool mark expert. But now, just because they have an expert listed doesn't necessarily mean that there's DNA. So everyone listen to that part. It's more important. There's a lot of reasons why the state may have listed a DNA expert, but one hasn't been requested yet. They may have listed a DNA expert to explain why there might not be DNA on the unspent cartridge, for example. And all they're there to do is, if the defense can raise enough hay about it, is to come in and explain how many cartridges they've swabbed for DNA. And I've been submitted samples from over 3,500 cartridges for DNA. And how many of those came back where you had a sample of sufficient quantity that you got a result? 1 or 5 or so. Nobody be panicking. And blood spatter, I could see why they had an expert, maybe why they listed a blood spatter expert.
For the F tree?
I don't remember. I don't know the stuff that detailed. So the defense is he's not even there, and there's no blood on his clothes that match. Normally, you kind of have a blood spatter expert to testify as to where there's no question that the person fired the gun, let's say. But they said it was in self-defense and I was 10 feet away. Blood spatter can show that that's totally false. Or, I fired from a certain angle in self-defense, when blood spatter evidence show it was coup de grace and the person was behind, the decedent was kneeling or, in a defenseless position, could be a number of reasons. But the DNA, that kind of struck me, that same slide you showed, I totally expected the expert, or the slide you have up rather, totally expected that a tool mark expert was flabbergasted. He had to front the money and then she cut it off, but I don't see DNA on there, denied or otherwise.
Right.
And
so in the motion, they actually talk about that some were approved and some were denied. So they only go through in that motion the ones that they're asking her to reconsider. So they don't tell us. So because they filed the request ex parte, and then her denial, her order based on what they filed ex parte, even though Nick got to read it, we, the public, didn't. So we don't even know who they actually all were asking for and which ones she approved and which ones she didn't. So
unraveling. So I heard Bob talk about it in his post trial debriefs that he gave. He gave 2, one that day. He was pretty spent, and then following day, and then you did one unwrap. But I thought there was some discussion about some of this stuff at the hearing. No,
about the money,
about these requests. Yeah,
I don't recall there being anything about these requests, but I could be wrong. I could be completely wrong and just not, and it may have been like minimal in my mind and I don't remember it. So somebody who was there or did a recap, or Sleuthy who wrote everything out, if you remember that, let me know. So I want to bring up a couple things to you before we move on, though, because so not DB Cooper was talking about Indiana judges can allow whoever, regardless of their qualifications. It's not a matter of pre-trial determinations in Indiana, apparently. So this goes back to
they don't follow Daubert. They can follow it, but they're not. So it's and we don't know. It's not that they don't follow anything. It's just not clearly set out. It's not clearly set out under Fry. It's not clearly set out under Daubert, but they do.
So she can't do whatever she wants about it.
Yeah, and they're not going to do it pre-trial. So the way that works is, I'm guessing, I don't know. We'll have to ask Kara, but so if the judge doesn't do a gatekeeper pre-trial, what they do is, no, I'm going to reserve that to the time of trial. So the state calls their first expert, and let's say it's going to be the tool mark expert. Under federal law and just about every other state law, say, Judge, we'd like a hearing under rule blah, 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 which is the expert qualification rule in federal court and 704. And it's, since most states adopt the federal rules of evidence, it's rule 704 in Texas. And basically what that says is the opposing party, the defendant, defense attorneys, get to put that expert on the stand outside the presence of the jury and find out what are the basis of your opinions are. What are your opinions? And then if there's any challenges, you raise them there. And this happens frequently in trials. For sure, it happened in that trial in Florida, that girl that sued John Hopkins Children's Hospital and got the hundreds of millions of all kinds of gatekeeper hearings that were never televised because they're boring as shit. Nobody understands them. And a lot of those were handled by deposition because it was a civil case. But in any event, it's usually done that way. Thankfully, Bob will be there, and one will be able to explain to us whether that was requested, if it was requested, what happened at this gatekeeper hearing, and we'll be able to lay out, what the opinions are going to be and go from there. But so it's up in the air. They DB Cooper is absolutely correct. They don't have a definite standard, but they do recognize Daubert but just not as a hard and fast rule. Said judges can use it as a guideline, and that's really all we know. And then the other thing, from what I understand, is Bob asked Kara about it, who would for sure know. And Kara said, we don't have anything hard and fast here. It goes judge by judge, court by court.
It's pretty unfortunate.
So what I'm thinking is like DNA or radar or a intoxilizer, if that's the brand of breath alcohol testing they use in Indiana. They don't make an expert come in and reinvent the wheel on that stuff. They have the discretion to speed up, cut to the chase on DNA, intoxilizer evidence, radar, maybe fingerprints. They can speed up the process and then make it a matter of cross-examination of the defendant, which is fine. but you kind of need to know what their opinions are, and that's why they give us a pre-hearing. But even if they don't, but it's why it's critical that you have your own experts, because everyone's familiar with the witness rule, the rule. So when one side invokes the rule, all witnesses have to be outside the courtroom until they're called, except experts. You can get it's routinely the parties say, hey, we've got these experts. Can they be excused from the rule? Yeah, if you excuse our experts from the rule. And then each expert sits in on the testimony of the corresponding expert. So when the state's tool mark expert's testifying, then the defense expert's sitting in there listening. But even if you don't have a testifying expert, consulting experts are critical. One, to help you prepare for the cross-examination before trial. Looking at their report, here's what you're going to want to ask. Here's what the problems are. Okay, what's critical here is not what's in the report, it's what's not in the report. Normally, you would see a validation study of this in the MMPI. There's a validity scale called this, for example. They don't put the validity scales in here. That means this person could be malingering. They could be exaggerating because they have not included. That's just an example that I know you're familiar with.
We learned that in the Johnny Depp Amber Heard trial.
There you go. So you know what validity scales are. Well, there are validity scales, so to speak, on DNA. There's all kinds of spikes and stuff in the X-ray technology that an expert can go, man, what they're picking up here for this allele here is noise. And you need to ask them about that. And so point being that, consulting experts can be even more important than testifying experts.
So that's what I wanted to clarify. So even if, so if I'm understanding correctly, then in the state of Indiana, the defense isn't always necessarily allowed to call expert witnesses, not DB Cooper. Is that kind of what I'm hearing? They're not always allowed to call their own expert witnesses because they're
No. So that's, I'm sorry. That's just, that's a misconcept. There's no state in Indiana. There's no state in Indiana if there's DNA evidence that the state has to have a DNA expert to get it in. And I guarantee you, if the defense wants to call a DNA expert, they have to let them do it. It's just beyond question. Maybe in Hooterville, Indiana, but even Delphi, and Allen County, you get to call your own experts in response to the state's experts. I mean, that's just so far unconstitutional. It's a deprivation. I guess I
shouldn't say that's not really what I meant, like about not being able to call them. But I meant like is how she has the ability to deny. I came out wrong on my end, but I'm okay with it because
I need a drink. DB, I apologize. I always appreciate your post. Seriously, sincerely. I should have known Teresa's probably been nipping it during the afternoon and, a little too much. No, he is correct that it's kind of loosey-goosey on the way. One, they're going to determine the validity experts under what standard. It's clearly an issue. But again, if the state calls a tool mark expert, the defense is going to be able to call a tool mark expert, or it's reversible error, assuming they're qualified. And again, they're going to be qualified. If they call a DNA expert, defense is going to be able to call a DNA expert. Where it may be iffy, and if people think she's prosecution biased, which she certainly is to some extent, the experts about susceptibility to false confessions due to conditions in jail or prison, those are going to be more of a gray area. And if she's on the fence, and you think when she's on the fence she always goes with the state, you're probably correct for having the concerns you do. Did that answer that?
Yes. Like I said, I kind of messed it up. So does it allow for her the ability to deny the funding for these types of experts to testify? Or can she just say no just because she can say no? Was kind of my question. Like, how is she getting away with saying, nope, sorry, you can't have any money for your experts, when the prosecutors are going to have those said experts? That was kind of my question.
It's very perplexing and troubling. Again, let's just use the tool mark expert. And from here, we know that they applied for a tool mark expert. She says, well, I'm not going to pre-approve it, submit, you front it, you pay for it, which I don't even understand that. But okay, so all right, I did. And ultimately he got paid. I'm presuming that's what that says. I can't really read it, but that I understand that she paid one bill, that he applied for more money and she denied it. Yeah, she can do that. Hennessy talked about that with Bob, that she has the discretion on that. What I'm saying is, what the reason why she gave that she denied it, and this is for the benefit of the people that instead of getting a Starbucks maybe 2 days this week, sent $50 to this fund, that, the reason she's giving for denying these funds are there's huge problems with that. You can feel really good about yourself with no matter which side of the case you're on, for giving money for experts, because a tool mark expert, her denying that improperly, that case is coming back for retrial. I'm just simple. If there was DNA and she didn't allow DNA funds for a DNA expert, not even to testify, but to just prepare for trial, that's reversible error. And so if you want to see this thing get done on time, on track, in a fair way that doesn't make it a show trial, as the original action attorney said in oral argument, practice, as he also said, if you don't, you want to avoid this thing being practice or a show trial, put those attorneys back on. And they did. And the same is true with, having an expert. I don't know what some people think. Usually at best, they just cancel each other out. The state has their pathologist, and the multimillionaires hire Michael Bodden or, Warner Spence, and, they come in and at best they cancel out. But it's a fair playing field. But if you don't give them to the other side, it's reversible error. And then if you don't request the funds, you just forget, well, she never grants money for our own DNA expert. That's why I didn't file it. Well, then on post-conviction, it'll get reversed for ineffective assistance of counsel. And then in Indiana, if you're held ineffective, you're off all of the lists for a year. You can't do any court-appointed public defender work if you're deemed ineffective for 1 year, I think I saw it was. But, it's this stuff's crazy. Everybody's known that tool marks are essential to this case. We know that if she's going to allow tool mark evidence, which that's within her discretion under Indiana expert law, and they put on a good expert that makes it sound like it's really good science and it's capable of including a gun versus just excluding a gun. A lot of states on tool mark on cartridges, they only allow you use it to exclude a suspect or actually technically a gun. Meaning, I've looked at it, and they would say in Texas, for example, I cannot say that unspent cartridge or that spent cartridge came from the suspect, the gun owned by the suspect. I cannot say it matches. All I can tell you is that I can't exclude it. It could be. It could have come from that gun. And versus inclusion, which DNA can do, I can say to a reasonable degree of certainty that hair follicle came from the defendant. That DNA, whatever saliva or whatever liquid it was in, came from the defendant to, a 1 in 3 trillion probability. They're different. One you can only include, can include DNA, but she may say, you can say it's a match. It came from the defendant's gun. So then the key is going to be, absolute key is a really good testifying expert for the defense to neutralize that. And it's just really troubling to me that that's been curtailed.
I agree. There's a case in Indiana that Travis talked about that they didn't even have the gun, and they said it came from the gun after 3 state experts said it wasn't from the gun. That's interesting. Yeah. Skip wants to know, do expert witnesses always disagree, or is everything subjective? Is nothing absolute, like they normally just counter each other out? Is there nothing absolute, like saying, no, this has to be this way, and if it is, then it is, and if it isn't, it isn't? Like, or is it just about leaving out the little details to make it the way that the one side wants it?
You got a big fancy degree from a leading California university in that. So it depends. It depends on the type of expertise. I'll lead with an example, and you can maybe give a couple. But let's say fingerprints. Fingerprints aren't really scientific. There's an objective component to it. I can't remember the term in the question. Is it all subjective? There's a subjective component to all fingerprints. There's generally accepted, 10 points of comparison. But, 10, 12 years ago, I know you learned this, the report came out of the National Institute of Health and the Academy of Sciences about many different disciplines of forensics and the problems in many of them. Fingerprints, they talked about a lot of the problems with fingerprinting, because fingerprinting involves, you put, one dimension, your thumbprint, but in the real world, we don't leave flat thumbprints, and they're on 3-dimensional objects, and so there's a subjective component to fingerprints. So you could have one expert say 10 points of comparison isn't enough. Ballistics, the real ballistics, where you fire a lead projectile down a barrel and it you have lands and grooves, and they make distinctive markings on the lead bullet from the barrel. That's more on the scientific end, but there's still a human is looking in a microscope and comparing one to the other and saying, this is a match, this isn't a match. And all the way to soft sciences, like the sanity of an individual. And one psychiatrist or psychologist examines them, and then another one does, and they're, kind of far apart. So that's a few examples. DNA is about the most scientific, least amount of subjectivism in it, but DNA doesn't tell you if a person commits a crime. What it tells you is that the cells of somebody were found on a particular item of evidence or in a particular location. And then logic and circumstantial evidence tells us whether there's any connection or not. But there's problems with DNA now, as it's so sensitive, highly sensitive, that it can transfer, and it can transfer in between people. So DNA sometimes can end up where it shouldn't be because of improper collection methods and storage methods. But there's a lot of forensics that it's really scientific, so on and so forth. But there's disputes, maybe disagreements, conflicts between the two experts. For example, whether you should use tool marks to include a weapon or just exclude a weapon. And that's actually a pretty big debate. But you have anything to add on that? I mean, I know you know examples where, sometimes there's a scientific test of some sort. They bring in an expert to testify about it, and there's just really not any question about it. The only cross-examination that's done is to clarify what's, clear-cut opinions and what might be more in the nature of speculation.
So the only thing I would add is, I think when it comes to forensic stuff, there's always subjective, because it never gives you 100% of anything, is kind of how I was always taught when it comes to, you're always included. It's a 99% inclusive instead of exclusive, except for if it's zero. If it's a 0% match is about the only time it's not subjective. If I'm trying to give an example that would be kind of simple. Like a paternity test. Let's say it's a paternity test. So there's a 99%, or they go through the whole 1.5, all the numbers. It's a 99% that you are a match and you are the father. Well, why isn't it 100? Because it just doesn't work. That's where the subjective 1% is. But if you're not the father, it would come out at 0%. So then you would be completely excluded.
That's a really good one. So
not as good as the ship, but I tried.
Yeah, no, that's awesome, because paternity tests were actually used in family court, which are DNA tests, were used in family court before they were in criminal courts. And then, so without getting technical, initially the FBI required, in order to submit a DNA test into CODIS. So you got this DNA you found, And
Mhm.
it's clearly from a sexual assault. It comes back, doesn't match anybody in the state system. So they created this federal system called CODIS. CODIS has requirements, what's necessary in order for you to enter something into it. Initially, it was 8 markers, 8 alleles. Okay. In order for you to submit something to CODIS, had to have 8 solid markers. Then they raised that number up to 15. I don't know where they are at now. It may still be 15. I heard they were looking at doing 20 before you can submit it to CODIS, because they're building up this database where they develop these statistics from and getting more and more people. So it gets more and more certain. But in the process of doing that, they've come back with some hits when they only needed 8 that matched 2 or more people in that state database in Arizona, for example. So that 1 in a trillion thing went out the window when they only used 8, because it came back in CODIS. You've got 2 people with these same 8 markers. And so science, like everything, evolves and it gets more and more precise. And scientific method is exactly that. Other people can take the method and improve on it and so on and so forth. But just the manner of testing, and, if a lab tech sneezes anywhere near the negative control sample, it's going to come up for that person. Not forgetting to glove your hand, and you shook hands with a detective, and then you go back and test, and that detective pat down searches. This is a real case. Detective pat down search the suspect without gloves, goes and meets, gets a buccal swab, collects that, bags it, goes and meets with the lab tech, shakes his hand. That's how you can get DNA transfer. And it happens and all of this testing involves human beings. It's a human endeavor. With every human endeavor, there's potential for mistakes. And then you've got the calibration and the validity of the testing instruments. But so I don't know if we answered a question, but your analogy is good. Some forensic evidence, there's really not much debate on. Certainly on the fundamental
I would say to include somebody, there's more debate than to exclude somebody, besides
Right.
the human error aspect of it. That's kind of where I stick with it.
Right. But like on psychology, like insanity defense, it's 100% objective. Well, they would disagree with that and be mad at me. They're saying that they're based it on science. They're, in the literature, there are reported cases of whatever, but they're given a professional opinion that, they can do some testing, psychology testing, to come up with some diagnoses that might show they meet the legal definition. But certainly in the soft sciences, psychology, sociology, those types of testimony, that person's question, they're exactly right. It's completely subjective.
Well, that's why they have the scales too. And everything that has to do with that, there's always like a scale, like this person sits on this scale at XYZ.
But if their defense is insanity, and they've met all the requirements for bringing that defense, advance notice, whatever, it would be reversible error to not allow funds for an expert to do an examination. And then if their opinion was that they were legally insane at the time of committing the offense, it'd be reversible error instantly, not to allow, even in Indiana, that that expert to testify for the defendant. I mean, just can't be done. That's their defense. Be like saying, my client wants to take this stand, Your Honor. Nope, I'm not going to let him testify. That's how fundamental it is on the clear forensic science, which in this case, we know for sure is tool mark experts.
Sure. Okay. All right. Do you guys have any other questions before I want to go into?
So impact of the gag order number 6. Get the question. I'm just going to cover a couple of these because they're really important. I have one more question for you. I don't think the gag order covers Hennessy talking about raising the money. The motion clearly doesn't violate the gag order, the actual motion, and why. Everybody knows from listening into your, what does the gag order apply to?
Well, the gag order is actually specific to the attorneys talking to the media.
Extrajudicial statements. And what's an extrajudicial statement?
Anything about the discovery of the case or
anything outside a court or a pleading. So it's it's in the pleading. Therefore, by definition, it can't be a violation of the gag order.
Gotcha.
So they're getting around the gag order with this motion. That's why it's not filed ex parte. At some point, I hope we can talk later on, not today. It's Good Friday. There's a couple of things been mentioned in yours. I know you've been real busy this week, but from what I could tell from the unraveling and sleuthy on your show, and it's a court recorder in the courtroom, which means they don't have one of those machines you see in the movies. They have literally a digital recorder, and there's microphones up at where the judge sits, the witness stand, counsel tables, and they're recording the audio. And then if somebody wants a transcript, the court recorder sends that audio out, usually has it transcribed, and then she goes back and edits it, makes sure it's correct, and then certifies it. And Sleuthy told me that that's what her understanding was of what was going on. And so under the Indiana open records law, I'm researching right now and looking into whether they would just have to give us copies of the audio tapes. So stay tuned for that. I saw Kara posted something in her Twitter, now called X, about that. Well, there's the order, no televised, no recording. She did say even though some of those courts have orders not to be televised, whatnot, they still stream. So she said somebody needs to look in that the judge may still, I doubt it with her, but if she puts it in something, it's worth checking out. We may need to, so if we can't get the tapes, really not looking at sourcing transcripts. There's at least one person in one of your members, followers, Teresa, that knows Greg's shorthand. And then I know of 2 others. We may need to send. Does everybody know what Greg's shorthand is? I know you're way too young to know what Greg's shorthand is, but
I just know of shorthand. I didn't know there was specific ones.
Well, Greg is the one that they taught in the United States. And before there was those funny machines, they were stenographers, but they did it with Greg shorthand in longhand, or in this special code that's really funky when you see it. But you can speak 150, 200 words a minute, and they can keep up just like a stenographer with a steno machine. But they're not up to super duper speed. But if some of these options aren't available, then as a community, I'm not a creator, content creator, whatever you call your all selves, but I know there's a group of you, and you're in each other's chats. There's regardless of what side, but how do I say this? There's a serious tier of creators that tend to focus on the case, the legalities, what the current goings on are, what the pleadings are. They're up on that, less of the drama. There's always a certain extent of drama, but there are some channels out there I've discovered that that's their primary thing. What this person is saying about this person that don't have anything to do with the case, that's not you. That's not Bob. I've only seen a couple of the unraveling, but there are many, many others. I can't name everybody, but you know what I'm talking about. So
I do.
We may need to help get those people together and then get a common fund, or to fund a couple of 3 Greg shorthand people to rotate. Although that nurse that the unraveling had, and then I don't know who did your notes that you went over. I'll say they're way better than mine. And Bob, God love him, he did way better than me. But that nurse that was on the unraveling and going through the stuff, I'm like, my gosh. And I think your notes were typed out by somebody, Teresa. Maybe I'm kind of all blend together. But
So Gambies was the one who went on the unraveling, and she did a great job. And Truth and Transparency was in the courtroom, and she went through and did a great job on keeping track of everything. Bob does a good job on tracking the legal parts of what's happening. But there's so many other little tiny components that some of us are like, we need to know that too. And then, so what I did was try to compile as many people's notes as possible. And I think Sleuthy, same thing. And then I sent her the compilation of notes, and then she put it together in a nicely typed document for us to read. So it helped tremendously, but it was like everybody kind of had to come together to put the pieces of what happened at that hearing.
Yeah, I've offered to buy Bob Google glasses, and he just would wear them in, not tell anybody. But he said, not unless I was willing to, get him out of jail or guarantee that he didn't go to jail. And so, all kidding aside, if we're not going to have television, it's going to be very, very critical for people to be comfortable with the information that they've been getting. My opinion, I'm biased, but channels like this one, Bob, others, you're getting as accurate information as you possibly can. It's impossible not to have bias with it. And Bob will be the first to say, I didn't care about the contempt stuff. And a lot of people were, because what is it? It's drama. It's entertainment. I didn't even care about that contempt stuff. The stuff I cared about, which is typical for a defense attorney. I don't care what people are saying about each other and social, it's not about them. Anyway, y'all heard that rant from him, not me. I understood his rant and why he was ranting, but thank God Allie was on that, kept him in balance. And then, hopefully something will come together. I just want to let people know that, there may, in order to have fact-based daily reporting on this, because you're not going to get it from local news, even experienced people, you're not going to get it from them. Local newspaper, they have deadlines, they have, which is usually before court's over. They're not going to dig down like people in the community, people who follow your channel are, and they're going to be thoroughly disappointed, and so it's going to require, okay, I'm going to cover the morning, then I'm going to go live with Teresa, or I'm going to go live with this person, and then you're taking notes, and then when you're done in the afternoon, you're going to go live with, I understand that the sense I get with the group that I'm talking about in general is that technically you all are competitors, but there's a significant overlap in who you have as hardcore members and subscribers to your channels. And I see a lot of cooperation and camaraderie amongst all of you that cover it. So in between the lines, I see even more in the background, so to speak. And so, I have every confidence y'all can come up with a plan that, because one person can't cover it all, even if they had perfect shorthand. And because somebody's got to be writing notes, and then, we don't know how full this thing's going to be. I heard, after the hearing on the 18th, ladies, even Bob said he'd wish he hadn't drank as much coffee as he did. The ladies, they were afraid to go up for a bathroom break because you lose your spot. So I'm hoping can figure out a way to beat the system. Whoever posted, they're absolutely correct. They can't prevent somebody from writing down notes, taking it in shorthand, although they can prohibit ink pens and require you to use a pencil. But other than that, I would think not. So I'm really hoping they get together on that. And, the last note I really wanted to cover was, it could be considered asking for a delay in the trial. I doubt it. And we've already gone over Jennifer Auger's experience. Yeah, she is a expert, and she would know how to handle those TUI requests. But and then if they get fined, I dedicated myself to make sure that they don't have to come out of pocket one single dime for a fine, and just stay tuned for that if you want to contribute to that.
I think that's a good idea too. Talking about just sourcing to be able to get certain people in there to do shorthand, I think that's my biggest concern is, and why I was asking if anybody who knows how it works with Judge Gull or at her courthouse or even at Carroll County, because some places will allow media passes and people with media passes to be more secure in having their seat versus somebody who doesn't. And some places don't care if you have a media badge or not. You're in line, and that's how it is. So I'm wondering if we did have somebody who was able to go in and do shorthand, how do we know that they'd be guaranteed a seat?
You wouldn't. And so
Right.
you'd kind of stage it. And do you line up after lunch? Do they make everybody leave for lunch and then come back and line up again, or?
I know this
know.
last time Bob said that there was concerns that you may not get your seat back. I don't know if you would have a totally different set of people who would line up and just get in. You know what I mean? I don't know if they would do it that way. I think that it's the people that are there in the morning. I think if you don't get in, then you probably wouldn't be there for the afternoon. I don't know how that would work, but I know Bob was concerned about not having his actual seat, but then other people said they did leave, have lunch, and came back and sat exactly where they were. There was just no guarantee of it.
Right. Okay. Well, there's, I know y'all know, there was, the nurse sat next to Bob in the hearing. And then, sounds like they've got their own little social club going. Probably pick somebody who's going to bring the coffee while they're waiting at 6:30 in the morning in line and all that stuff. But, I think they could get that logistically figured out. And I don't know on the press passes, of course, what she considers press or not is kind of the first question, based on that line and the on the photos. And well, they're not media because there's a media privilege for divulging a source. You and I went over it on another episode, but like attorney-client, doctor-patient, there's press source. And even though I don't think they were asking to give a source in the technical sense, it was more, where'd you get the photos? But one of the persons that submitted a letter, we don't need to say his name, here he's north of the border, kept citing that statute. And it's like, well, what you're writing in your letter to the judge, that statute doesn't even apply. You're saying who your source was, and then you're citing a privilege saying you don't need to give your source. But, pretty crazy. But any event, she doesn't apparently consider YouTube creators media, which is fine. I think there are people there that the main thing to be considered media in Indiana is if you derive income from it. I don't derive any income from media. I don't have a YouTube channel. I just come on to different other creators who may earn income, because my thing is about educating people. And so I'm not in the media, but you certainly, you just have to show some sort of income from this. I know Bob can, and I'm sure some of the other people can. Under the definition of what media is in Indiana, it would be no problem whatsoever. And then, that's a good question. Are they going to do anything? And I guess the easiest way to answer it is find out, what media was there, and were they in their own area? Bob mentioned all the seats were full except for 3, and then a person came in. I just remembered this just a second. One person came in from Court TV and took one of the 3 empty seats, and there was 2 empty seats in the morning. Which tells me if the Court TV person can walk in right before the thing, they must have press credentials and there must be a few seats reserved, but somebody needs to, right? But
True.
I don't know if you
Okay.
remember him saying that. I just kind of caught that he was name dropping, frankly, you know. Knew the reporter from Court TV, and he said, yeah, you know, there was, it wasn't completely full, 2 empty seats. And then he said, well, there was 3, but then Court TV. And then he named of course, the reporter, because, you know, they're buds. But he was name dropping. It's the only reason he divulged that. But following up on your excellent thing, yeah, they need to determine that. Sometimes you wonder how much you want that court to know, or, you know, how much you want to leave them in the dark. But, you know, obviously it's to everybody's advantage that's kind of in the family, so to speak, amongst YouTube creators, to divide that up to the extent they can. It's going to go 9 to 5 with probably an hour 15 for lunch. Even Wednesdays when it's normally shut down. Now, how would you like to be Shoma Shabbos or whatever other religion, and the judge says, well, look, you know, my intent was to go Saturdays so we could be done by a date 3 weeks out from now. But if anyone objects for any reason, for religious reasons, not on Saturday, raise your hand. It'll extend the trial, you know, probably another 3-4 days, but we're good with that. I don't know. Kind of crazy. I wouldn't want to be the one having to answer that, but
Right.
What are your thoughts on that when you read that, Teresa? That
Which part?
About that a juror for religious reasons could opt out the entire jury. So they're going to pick 12, probably 2-3 alternates. She's going to go Monday through Saturday, including the extra half day on the Wednesday, and will go on Saturdays unless one of the jurors has a religious objection.
Well, I would only think that would matter depending on how they do the questions for the jury selection. I mean, I highly doubt they're going to be like, hey, so this trial is going to go, you know, Monday through Saturday. If you have any religious reasons, why not? And then we're still going to pick you. So they can either just do it that way and say, hey, this trial is scheduled, you know, Monday through Saturday.
The way she'd have to do it to be constitutional is she'd pick the jury. Okay. She got
Correct. Well, that's where I'm going next. Yes.
And then ask, okay, here's the plan. You know, does anyone have a problem? Now, I guess you could go early. We estimate it's going to go 3 weeks, 15 trial days, or 10 trial days starting next Monday, or however she does it.
Right.
And give a range, adding if they don't go on Saturdays and do it that way. So when you were reading that thing about that, she's got an entire day to swear the jury. It takes 10 minutes to swear a jury, and then they're read the introductory instructions. Don't listen to media. Don't go out and investigate. You're allowed to take notes. You're not allowed to take notes. Whatever. At the most, that's an hour. So I'm guessing she's using that time to advise them you're going to be sequestered, what the rules of sequestration are, and they do need to do this. They usually say, okay, when you come back tomorrow, you know, come back with a suitcase. But she may let them go home early and say, I'm giving you the rest of the day off to make arrangements with school, make arrangements with childcare, make arrangements with your work. If your work gives you any trouble whatsoever, let me know, or tell them to call me and I'll straighten them out. And so she may be given, but then it seemed like the next day she had a bunch of time that wasn't needed. And she had opening statements on Friday, right?
She does, yeah.
Monday.
So that was my thought, is maybe if the jury's picked by Wednesday, then Thursday she would swear them all in and have them transported down to Allen County for opening statements Friday morning. So maybe Thursday is considered a travel day after they're sworn in.
Okay, all right, yeah, I guess so. But it's certainly not just to swear them in. You were absolutely correct. Takes 10 minutes.
That's what I was wondering.
Most. Yeah. All rise, raise your right hand. Do each of you solemnly swear you will, and then whatever their oath says. And then swear or affirm. In Indiana, they probably still have at the end, so help you God. But yeah, it's gonna. Wow, that kind of surprised me, given the budgetary crunches that they were going to sequester right from the get-go. But with the insanity going on with the letters to the judge and so forth, I think that's a good call. You just don't know what some crazy or misguided person will do, and inappropriate, that requires a mistrial. So why chance it?
Right. I think I actually said transport them to Allen County. I don't know if I said that, but somebody corrected me and made sure that they're going to go to Carroll County. Or I don't know if they're correct. I don't know what part they're correcting, but I'm sure I said something wrong.
I heard there wasn't much in the way of hotel rooms in Delphi, so
there isn't any.
That's why you said last week. Yeah.
Yeah, and then somebody else said like there's a couple like Logansport. They named a couple different cities that are close by. They're like 10, 15-minute drives. So those are going to have to be where the jury ends up staying, because there's nothing, unless they're renting an Airbnb for the jury. I mean, I don't know. Other than that, they're going to have to stay at the hotel, which is not next to them.
What was your next topic that you were going to get into?
Well,
we covered everything on that. And
I'm just going to go through Hennessy's stuff. You're welcome to stay up here with me and go through it. I'm going to play a clip from the news about people thinking that the raising of funds is not okay, and then I'm going to go into unsolved stream and show Hennessy's interview from earlier. So that's what we're about to do.
Great. I'm going to go grab a quick glass of water, and I'm just going to hang back and listen on here with you. And then if something raises a question that you have for me, I'd be happy to answer.
Sounds perfect. All right. So we're just going to do that. I'm going to play this, so you'll be perfect time to go grab something to drink. I'm going to grab a new fresh Dr. Pepper. So this was a clip from a couple days ago that I thought was interesting and I wanted to play. So here we go.
And Richard Allen's defense
You can't
team
hear
now
it.
asking the public to help pay for expert witnesses to help testify in the Delphi Murders case. Teammates Cody Fisher breaking down exactly how much the defense team has raised so far and what this means for the case.
The defense attorneys for Richard Allen are asking the public for $25,000. Since Monday, they've already raised more than half.
Crowdfunding is sort of kind of an iffy gray area in this space with criminal defense. In fact, a lot of sites like GoFundMe explicitly do not allow you to crowdfund criminal defense for violent crimes unless you've been exonerated.
Anya Kane and Kevin Greenlee of the Murder Sheet podcast tell me this crowdfunding campaign stems from court filings that the public is not allowed to see. The defense asked Judge Gull to approve funding for specific expert witnesses.
We all have no ability to know what exactly they asked for, what they wanted. And from the defense's telling of this, the judge approved some of those experts for funding. and then denied others. So it's very hard to assess from the outside what that means. You know, was this a use of judicial discretion, or is this fair to the defense? Because we just don't know what was denied.
She's well within her rights to deny those requests. And it's not at all unusual for judges to deny requests of public defenders. It's just part of the process. Public defenders, for better or for worse, don't get blank checks to get as many experts as they want.
Why do these experts need to be paid?
Well, when experts come in, they are using their knowledge and their skill set, and they just typically get paid. That's how the process works. That would be is if I tried to subpoena someone to do a free day's worth of work. That would be unfair.
The Murder Sheet podcast says this fight over money could impact the timing of the upcoming trial in May.
I feel like the fact that money issues are being debated right now is a pretty strong sign to me that this is not going to happen in May, that we are not going to see a trial in May.
While the defense team is turning to the public for funding, we're still waiting on a ruling from Judge Gull about whether or not Allen's attorneys, Baldwin and Rosie, will be held in contempt of court, which could potentially throw them off the case again. Reporting in Indianapolis, Cody Fisher, Wish TV, ITMate.
All right, so I know everybody's like all up in arms. I did it on purpose. Well, one, because they can't strike me playing them on a news channel, and two, I think it's important to listen to what the I would say other side of things is, and then we're going to go into what Hennessy actually has to say and how what the correct answers would be. So that's why I wanted to play that, because this is essentially what is happening on this other side, is saying you can't do this, this is illegal, you can't use crowdfunding. But I think what people are not understanding is that GoFundMe it's part of their terms of service. It's not about the legality about it. It's about you can't use it under the terms of service of a GoFundMe. Now, there are other sites that don't care, and that's what we're going to talk about. So that is incorrect. The other thing that I wanted to bring up is actually the newscaster who says that he's waiting on, that we're still waiting on the resolution behind the contempt hearing where she could potentially throw them off. I think we've gone over that enough on the channel that I think everybody's pretty much aware that the resolution is not them being taken off of the case. That is not the quote-unquote punishment to fit the quote-unquote crime. So I just wanted to show you guys that, so that way we could see here is a leading team of people on the other side that I feel are pushing this agenda on how this is so bad when this is necessary because of the fact that Gull is denying them the ability to offer Richard Allen a fair trial. And I know this pisses a lot of people off when I say it, but the trials are not meant for the families. So people are like, oh my gosh, anybody who supports this fund is like against Abby and Libby. Anybody, in my opinion, who supports this fund is backing the constitutional rights of all Americans, number one, and number two, to make sure and ensure that Libby and Abby are getting a fair trial, because otherwise, and I've said this repetitively too, everybody has the right to appeal. Not everybody actually has the grounds to appeal. And I think that's a very big part of why everybody's like, well, they're going to appeal it anyway. It's very different when you actually are setting up and giving the defense team grounds for an appeal. So my example for this would be like when we went to the Supreme Court. When we went to the Supreme Court, everybody has the right to, or all the attorneys have the right to submit the writ, the original action. They have the ability to do that. Now, the Supreme Court could just be like, nope, have a nice day, see you later. They could also say, here, we're going to make a decision on it in writing, or hey, we're going to make a decision after we hear your oral arguments. We saw that happen in a variety of ways throughout those times. Now, it's the same thing. So yeah, he has the right to appeal, The difference is giving them grounds to actually get the appeal, for the appellate court to say, yes, we're going to take a look at this. And by taking a look at it, there's a very good chance we may overturn whatever decisions you've made. So I think that those are semantics when it comes to words, but you know how you guys know how I am with those words. Like, it's a big deal. Grounds and rights are not necessarily, they don't go together. So I think she's building the case or allowing things to happen with her rulings that are allowing grounds for an appeal is where I'm at. I know the dog started barking. Sorry, it just totally distracted me. So I wanted to talk about that. And then, like I said, I wanted to go to the interview with David Hennessy this morning that Allie from Unsolved Crimes and Bob from the Defense Diaries did. Give me just a second to pull that up. And Travis, do you have anything you want to add to that? Why I pull this one up?
No, well said. Great analogy. Anyone can file a piece of paper in the appellate court called notice of appeal. That's technically appeal. Whether you have substantial grounds for an appeal is a completely different thing. And you're right. A lot of stuff, a lot of issues people appeal on are disposed of summarily. But the things that, for example, the decision whether to take removal of counsel as an original action or wait until after the trial, the Indiana Supreme Court agreed that there was structural error, meant that no matter what happened, other than an acquittal of Richard Allen, that thing was coming back. And so that was very, very well said. And then I posted 3 or 4 in the Defense Diaries Facebook group, 3 or 4 different local print and news channels. And one got an interview with a law professor at the University of Indiana Law School, the executive director of the Public Defender Council. That's the quality of people they were interviewing. I just wanted to note, I did not link to that last television segment. That didn't seem to have the caliber of reporting that the others did, but agree with you 100%.
Okay, so let me go in. And so this is Allie from Unsolved Crimes Uncovered. If one of the mods would make sure you guys drop her link, she does an amazing job of putting, honestly, my favorite part about it, she's just so statistical and fact-based. But she had a dual stream with Bob Mata, but we're using her channel to play this. So, goodness gracious, hold on one second, sorry. There's probably a cat outside or something, and they're just like ecstatic about it. So she says hello to everybody and welcomes them in. I think we start about right here.
I know that we're going to have a lot of interest in this session today. So if you guys have questions, we're going to be taking those questions at the end. And unfortunately, I can't review every single.
It was completely her idea. She set it up. I'm computer illiterate. This never happened without her. And next,
about how Allie's amazing because she helped set up this
over 450 people
fund
that have actually donated. But the model is,
can you guys hear this?
It got launched when the prosecutor added 2 more experts. And I mean, it just seems logical. I don't know how you can make a conclusion that defense experts aren't necessary if the prosecutor has experts. If a prosecutor has any kind of expert, the defense should be entitled without question to a similar expert. So that is the need. And let me pull up a list. State has a blood spatter expert, so the defense wants to get one. The state has a DNA expert, so the defense wants to get one. The state's going to call an Odinist expert, so the defense wants one. The defense needs a psychologist, which Andy and Brad have been paying out of pocket so far. They have a ballistics expert, as you all probably know. There is an unfired shell casing that they say matches a gun recovered from Richard's house 5 years later. And one firearms examination has been criticized nationally as not a science. It's completely subjective. And even firearms examiners will admit that. They don't quantify anything. They try to match striae on fired bullets, which is closest to reliable, but unfired cartridge casings, there's just not enough on them to match them to in particular. So Andy and Brad have been paying a ballistics expert out of Tennessee out of their own pocket. They're going to need a confessions expert. And to kind of dovetail with the psychologist, because the rigor of his confinement has affected the alleged confession. And, you know, in 41 years, I've never seen a man charged with 2 counts of murder, with no criminal history, confined in a state prison, shackled for a 3-hour trip, shackled through every court proceeding. I currently have a client charged with 3 counts of murder. He's in the local jail. He's not shackled when he comes to court. So, and the other thing about the circumstance of his confinement, 4 attorneys have witnessed it, they've documented it, and they filed pleadings about it. Andy and Brad early on. And then the judges handpicked replacements after she disqualified them, confirmed it. The other thing is the whole odinous thing has been kind of poo-pooed by people, but the hand-picked replacement attorneys found it to be true, and one of them called it scary. So back to the experts. I set a goal of 20.
Okay, I'm going to pause it there, because I just want to talk about that. There's also this commentary that I've seen going around since this interview this morning about the fact that Hennessy is under a gag order. And I think Travis kind of clarified earlier exactly what the gag order covers. But he's not sharing anything that has not already been put out in motions, either via the defense and also via the prosecution. So what he's talking about is pretty much public knowledge anyway. And he says, like, hey, if the prosecution wants, a blood spatter expert, then the defense is going to want a blood spatter expert. If the prosecution wants a DNA expert, then the defense is going to want a DNA expert. Those are all none of those things give up any type of information regarding the actual case. Go ahead, Travis.
Nor is it a comment about the actual case. He's commenting about why he set up a fundraiser for experts, and that necessitates talking about the status of the case for context. I agree, it's not even remotely close to violating the gag order, but and I'm glad you paused it here. He said the state recently named 2 new experts. Is that the DNA and the blood spatter?
Well, in one of the last state's motions, they added in that they wanted the odinous expert. So I'm not sure, because it's so problematic, because we don't get to see everything that they are putting out or all the things that are happening because of this lack of transparency. But they talk about that they wanted the odinous expert.
Right.
That was one of them, and I'm trying to remember what the other one was. So I don't know if he's referring to those 2 or if he's referring to a blood spatter and a DNA, because if you let me pull this back up real quick. because in here we know that these are the ones that they were denied based on being unsupported.
Yeah.
So I don't know. Did they approve any other ones? We don't know that.
And then what he's saying there, he said it much more eloquently than I did, that if the state wants and gets an expert, it's just automatic that the defense should get an expert to counter that, assuming they're qualified. So, whether somebody's qualified on Odinism or not, who knows? But anyway, yeah, he's echoing that. I agree. The thing that, he's in violation of the gag order. Frankly, I think he's hoping she goes after him for that, but I doubt it. Nick would have to file a motion, and again, because of the gag order and because of this protective order, that's why he's a lead pipe. He has orchestrated how to get out the information they're getting out. When did she say the 600 questionnaires went out?
I believe she said the 13th, but somebody can correct me if I'm wrong.
Okay. So, and it's all legit. And me personally, I think to a large extent, she's created that by the denial of funds and, necessitating getting this other attorney. That's all I had on up to this point.
Okay.
Other than, from what I understand, that's Bob's suite at the Delphi Ramada where he stays.
This is?
That's a joke. Okay.
I was like, that's not his Zoom background or something like that. It's like a StreamYard background, I think.
It's
I'm like, if that's his suite. Okay. You sent it in DM. Okay, thank you. All right.
The Ramada at Delphi. Okay, come on.
What, the Ramada in Delphi? I didn't even hear that part. Okay, the unraveling got your joke. Chelsea got your joke. I didn't get the joke.
5,000, and that was a wild guess because I don't know how much Andy and Brad had spent already. They're getting $100 an hour, so that's low pay. But so today I reached out to them early this morning, and they're looking at thinking they need closer to 35 or 40. I haven't talked to Allie about that yet, but we're going to probably see if we can increase our goal. It's unfortunate that it's necessary. It truly is. And, if people have read stories about how the criminal justice system is dependent upon your wealth or your assets, this is a case where it shows you. I mean, one side, 230,000, the other side asking for 35 or 40. So anyway, that's what they need.
Okay, so I want to pause it here just to reiterate that they are upping the amount needed. And I know that Allie is trying to change it on the website, and she'll update it as soon as she can. So I don't want people to think that they have met what they are going to ultimately need based on it being over the 25,000. So just an FYI, if you're listening and you want to contribute, please do so. They are going to change it to, I think, Allie can correct me if I'm wrong, but I think to 40,000.
That's why
that's what I heard, but from what you just showed, and when I first saw the 25 and what I thought it was way too low. But I could understand it, that maybe that was going to be an initial amount and then see how it went. And then maybe the court started granting some reimbursements, but I thought it was just way too low from what the experts take, and what these experts are charging reasonable amounts, and the experts that they're asking for are reasonable from my experience. I know that's a lot of money for anybody, and they actually cracked some jokes here, I think, in a couple of minutes, if I have the timing right, when I came in. And my brother was a plumber, and I'd kid with him all the time how much more than he made from me. But all kidding aside, the fees that they're getting are just abysmal compared to other states. That's not what we're talking about. It's having the necessary tool. It's like having a legal pad that all of us attorneys carry and a pen. I mean, that's what you have to have experts on this type of case. I know others have said it much more eloquently than I, but I mean, it's just so fundamental. I like analogies. We can't operate in court without a legal pad and a pen. Maybe the younger generation can do it with a tablet. I don't know. But, you got to have one or the other. And in a murder case, when the state's got, what did he just list off? Blood spatter. This is what the states listed as their experts. Blood spatter, DNA, odonist. Can't remember if they had a psychologist or not. So they he called it ballistics. It's tool marks, but he's old school. He's never had an expert jump his ass for calling them ballistics when they're really tool marks, just like psychiatrists jump your ass when you call them a psychologist, but because they're an MD. But in any event, Bob's been saying what he's saying. I'm just so glad that Allie was able to finally be able to get him on camera, talking about what the real need is. But he's not bullshitting you. Others, Kara talked about the thing about experts in her tweets, that great analogy, like trying to fight a prize fight with one arm tied behind your back. And it really is. Even if they're not going to testify, just having who here knows about tool marks enough that you could prepare a meaningful cross-examination to go into all of the areas that Lead Pipe just described as being subjective. It's tool marks is recognized as subjective all across the country. Compared to ballistics and lands and grooves, I think, and he said where there's percentages and it's a lot more scientific, less subjective, but tool marks on the unfired casing we talked about earlier, is primarily subjective, and that's scary because of bias, and it can be sinister bias that the expert works for the state. It can be subconscious bias, but we all have it. So I'm really glad they got him on there, and I'm glad you paused there, T.
Yeah, I'm so happy that he came on, because I think that it really verifies and validates what they're truly trying to do, instead of this, people just making it up. It's very transparent. Like, here, this is what we want. This is what we need. This is, what we plan to do with it. This is why we asked for this amount, and I mean, I don't know how anybody can say, I'm very curious how the the opposing side is going to be like, nope, this isn't, you still can't do it. Because the only thing I've seen today is now Hennessy's breaking the gag order. I think there's probably going to be some pushback based on that. They don't, people are like, no, we don't want them to have the experts because we don't want him to have some type of, advantage or whatever you want. It's not even an advantage. That's not the right word.
And I'm telling anybody that's worried about that, Judge Gull cannot order Hennessy what to do with those funds. She cannot order Rosie or Baldwin not to hire experts with those funds. Seriously, I mean, it would be the best day possible for Richard Allen if she came up with an order like that. Because you know what happens? It's an OA, and she's off the case. So it'd be the best day in the world for her to order that. They can't raise funds. 2, they can't expend them on experts. That Rosie and Baldwin can't accept the money. This guy has been on the Indiana, look him up, Indiana Public Defender Council, not the commission, the council. They filed an amicus brief that was accepted by the Indiana Supreme Court on the second original action. They are a quasi-governmental entity created by the legislature and funded with funds from the Indiana Supreme Court and the Indiana legislature to improve public defender services to citizens accused of crime in Indiana, Hoosiers, who can't afford a lawyer. He's been on the board of that from its inception and an officer at times. It baffles me how much, people instantly learn or know about raising money for experts or, a lot of different things. You can't describe the crime scene photos in a Frank's motion. I don't know where they come up with it. I understand probably there's a large segment, I sincerely feel, say those types of things out of love, respect for the family and the parents, and somehow see some sort of that's equating. But then there's, a fair amount that just say stuff to say stuff, and who they are. You got Kara and Hennessy, and you got law school professor, executive director of the Public Defender Council of Indiana, all saying that this is why it happens. It's unfortunate. Nobody's saying, "Oh my God, this is illegal. It's ethical." No, you're not going to get it, and nobody should be worried about it. And I just, it's probably going to require. Maybe laying out more of a budget in general, because you don't want to lay it out specifics, but good. I'm glad. And we'll raise another 25,000 next week.
And I think it's also very important that people understand that we're not, people who are donating aren't necessarily all donating because they're adamant that Richard Allen is innocent. People are donating because they want to make sure that it is a fair trial. And they want to make sure that if the prosecution has an expert, that the defense has an expert, because we've seen so much imbalance with I should say, even if you want to call it the perception of imbalance for a year and a half now, people ultimately want it to be fair. And I also go back to, and I don't mean to bring this back up, but so Kyle Fortson, who was somebody who actually believed that Richard Allen is probably the right guy, even in his communications stated he just wants things to be fair and he wants people to stop hiding shit. Somebody who was very vocal that he believed that Richard Allen was the right guy still was doing things, and even if they weren't the correct moves or the correct or we don't agree with what he did, his purpose or his thought behind it was because he just wanted it to be fair. He just wanted it to be fair.
Yeah, and personally, I'm in the camp. I don't know. I don't even know. You know, I've heard you and I've heard Bob talk about the PCA. I came in first week of October to answer some legal pleadings on removal and questions that were coming up. You know, I know that the listening to Bob and you and others, PCA is thin, and you know, I don't know, and you know, I don't really care. I'm, you know, pro police. Most of my clients are police officers. Last murder case I had was a on-duty police officer a couple of years ago that we got acquitted. The experts in that case were $75,000. You know, obviously I care about the cases that I have a client, but this one, you know, I don't know. I'm in the camp. I don't know. Nobody else knows either. They have a theory and they have a person they like for being the perpetrator, and people do become vested. Teresa, you're absolutely right. They get vested in a theory. They've had to fight tooth and nail to get information. One to the point where she felt like she had to pose as a blonde-haired something, talking to one of the suspects on the phone, but I digress. But, you know, you're clawing and scratching to get any information, and then some of it's totally made up, and you're thinking, okay, there's this person that out there, and you know, and then they're saying, well, no, it's safe. And then I heard today they then said, well, no, we're closing the crime scene down again for a few more days. Well, how could it be safe for us to go back out on the trails? The community, and then local community geographically, and then YouTube community worldwide. Yeah, you get vested, and then you know, it's not the person that you figured out. There, you know, there's things. No, and they made it very, very clear. It's not. This isn't free the West Memphis 3 or free the Chicago 7. It's let's do what's right. For me, without them saying it, and you know, let's stand up to the bully, and you all can decide who the bully is. I'll let that, you know, everyone's probably got maybe one of their own, whether it's prosecution or maybe the forum where it's at. But you know, we just want to see what happens. That's fair, and I'm really glad you're going through this and making the comments that you are. That's all I had on that.
Oh, Travis, thank you. I'm glad you're here to do it with me. All right.
And David, I just want to clarify for people in terms of when you're talking about Brad and Andy getting $100 per hour, that is their fees. They are both private attorneys. They were both appointed as PDs on this case, meaning they're getting paid out by the county, but they're getting for themselves for the thousands of hours of work that they've done thus far, and for the work that is yet to come in the trial. They're getting $100 an hour, which I understand if you're a laborer, you're like, well, what the hell are they complaining about? That is far below the going rate for attorneys of that caliber anywhere in the country, just so you guys understand. And this fundraiser, and David and Allie and I we were working on the language of that, wanted to make clear that these funds are not going to Andy and Brad. These are exclusively for experts to be retained, for the experts that have already been retained, to keep them working. Because once an expert goes through whatever they've been paid on the front end of their retainer, they need a re-up. They expect more money for them to continue to go. If they've got an expert that's done, gotten halfway through their examination of, say, phones, and they run out of money, they're going to call Andy and Brad and say, hey, we're out of dough. You got to send us some more money. And they're going to stop working. And then what also means is that if they haven't prepared a report at that point, and they're planning on preparing a report, they're not going to do that. And that means that if they're not going to prepare a report, that they're also not going to come to testify at trial. So these are all the things that the money has to come in for the two experts that they have given some money to. And I believe David's right. I think it's out of their own pocket. I think that they're reimbursed for that by the county, but
she denied it.
Really?
Yeah.
Oh,
Hey, I don't want
isn't that a violation?
No, not in Indiana's system. They have to ask the judge for money, and the judge can grant it or deny it. And Rick's not in a position for them to appeal that, because he's not going to make it another 8 to 12 months. But I hate to detract from the seriousness of the topic, but can I tell a joke?
Yeah, I'm going to pause it right before his joke, because I want to talk about this for a hot minute. And I'm hoping that, Travis, with you being here, that you can help explain this to me and if I have it incorrect. So my understanding, when I was looking up the information on how the typical, prosecutors in Indiana and the typical public defenders in Indiana get paid or get their money from whichever fund, I was under the impression that the prosecutor, like Nick McClelland, gets a set budget from Carroll County Council or the county council, and then if he needs more money, he goes and he presents why he needs more money, and then they have to approve whether he gets more money or not from the county council. I was also under the impression that for the public defenders, because of this, and Hennessy's going to talk about it in a minute, which is why I want to make sure I understand what I'm talking about, that for the public defenders, not every county in Indiana has a public defender office. Carroll County is actually one that doesn't have a public defender office of its own, which is why they kind of outsource what they're doing. Now, I thought if let's say it was Labrado, who was he's actually like the chief public defender of Allen County, right? If he was going to request funds, he would request the funds from the public defender. I don't know if it's the council or the commission, but one of those, that he would actually request funds from them for expert testimony versus actually asking the judge. Am I incorrect in that assumption?
You're 100% correct. The only thing I'm unsure of is whether there's a statewide fund for experts through the commission or the council, or each public defender office. If it's a non-capital case, each public defender office applies for a budget, $2.5 million to pay the attorneys' salaries. They don't pay by the hour, they're employees, their salaries. We need, they have 1 or 2 investigators that are salaries, so they don't need to pay them by the hour. And we need $200,000 for experts for the year, absent extraordinary circumstances. I think that's county by county, except if it's a death penalty case, and then the state and the county split the attorneys and they split the expert fees. But in general, you have it exactly right. The mechanism is what's important, that you go to, he was one of the attorneys briefly, the head of the public defender office, and you go to him and say, yeah, I want to hire this, and I want to hire an expert on basket weaving. Okay, well, 1 through 4 are approved. What's this basket weaving about? Well, I don't know. There was a basket in his house and I was curious about it. You know, something crazy they're not going to approve. Or they may say, well, you've got Dr. Jones here. We had some problem because we communicate, all of the offices communicate. There were some problems with that expert's testimony in his last trial for whatever reason. Maybe you want to look at somebody else, but you're not having those you're not having to go to the judge and, beg for that. You're going to somebody that knows how to defend serious cases, knows that experts are required, knows how to utilize experts from the defense perspective, and knows what works and what doesn't work. When we're newer, younger attorneys, you see these other lawyers try these cases and win from whichever side. And the tendency is just want to get every expert you can with maybe not thinking it through. But with these attorneys and the experience and the caliber that they know what they need. And that's exactly right. That there would be a fund available that they could ask for if they were in Allen County. But smaller counties, you got to go to the judge. And that's how Travis County, where Austin's located, and surrounding counties are that way. But, we have a mechanism that if we're denied experts, we kind of have a mini accelerated appeal. We can go to the presiding judge of the region, and that judge is located out of county. But one thing I didn't bring up in terms of funding before, when you see documentaries about a case while it's pending, they show a lot of trial footage. I haven't been involved one as the subject of it, but had a good friend that was the defense attorney for a murder where boyfriend shot and killed his girlfriend in her apartment. Then he got an ex-girlfriend to come over and they cut up the body. Well, they made a documentary about the girlfriend who came over and helped the murderer. And he said, yeah, we'll be in the documentary. I'll give you access to her in a way that, won't compromise her case during the trial. But I want a, whatever, I don't know the amount, say $25,000 honorarium. And that money is going to go to experts. That was done in West Memphis 3. Again, raising money for experts is nothing new. And if attorneys are presented with an opportunity, they're not getting money for themselves to be in the documentary. They're trying to get anything they can for experts because partially denied what they wanted. West Memphis 3, the first episode on HBO. At the end of the documentary, you'll see that we paid an honorarium to the defense attorneys to help defray litigation expenses, experts, and also the same honorarium to each of the families of the 3 victims. You got to do what you got to do. That's what I had on that. Good, but you have it exactly right, Teresa.
Okay, so I appreciate that because I was thinking, I'm like, that not everybody in Indiana has to go, not every public defender in Indiana has to go and request the funds from the judge. They have, I thought they had, like, I couldn't remember if where the fund was or what the fund was or who they had to ask, but I was like, that makes more sense. So thank you for clarifying. Okay, we'll listen to Hennessy's joke, Mr. Funny Guy over here.
Yes, please.
All right. The lawyer had a kind of a simple, minimalist plumbing problem. So the plumber comes, does the repairs, hands the lawyer the bill, and the lawyer just goes berserk. He says, "This is outrageous. I don't make that kind of money." And the plumber says, "Neither did I when I was a lawyer." That's funny.
It's still funny.
That's good.
That's pretty great. That's pretty great.
Yes, it is.
So, David, as far as you see, I mean, to me, 25 was a very conservative estimate, and I get where you were coming from. When trying to kind of just pick a number out of the air, it's tough, not knowing exactly everything they need. But and we certainly don't want to be here, on bended knee asking for more money. But I think we're basically here on bended knee asking for more money.
I hate having to ask.
It's
I
crazy.
really do.
Right.
But it's not going to be a fair fight if we can't help the defense get some experts. And that judge is not going to budge. And
Right.
you can't, she says, "Well, maybe I'll reimburse it." Well, you can't plan a trial. I mean, if you can't know whether you're on the hook or not, I mean, the time that these two attorneys have taken from their practices, I mean, they've taken a huge hit already.
This is really important, right here.
David, why don't
Teresa,
you take a moment to explain?
I couldn't get to the pause button quick enough. Sorry.
They're going to talk about, now what they could do. They do have a path forward that they could appeal in an interlocutory appeal the denial of the experts, but it would extend the trial date out at least 6 months, probably 9. And this is really important for people to listen to that may be on the fence about the appropriateness of giving either for themselves or others. But this part is really going to hit why they're in this position that they are, of going to the public for expert funds. It's critically important for people to understand this part.
Okay. Let me keep going.
Yes, please.
I've been spending since the fundraiser kind of came out to the world, and we've got two very polarized sides on this case, as you're well aware, as we're all well aware. And the things that I see from the other side on this thing, and again, like I just want to make it clear, this fundraiser is about getting Rick Allen a fair trial. Okay, none of us know what's going to happen at trial because the evidence hasn't been vetted. This isn't us all pounding on the table saying Rick Allen's innocent. I think that probably the three of us believe that he is. However, that's all dependent on what comes out at trial. But what we're talking about at this moment in time, what we need right now, and what every American needs to be concerned with, is that this guy deserves and has a right to a fair trial, and that's being derailed. And can you just explain kind of what we're talking about with respect to leveling the playing field in terms of why we need these funds because of the state's seemingly unlimited resources?
Yeah, but that brings to mind the contempt proceedings. I got involved when after she was wanting to disqualify him, and then Nick files contempt. the day after the Indiana Supreme Court reinstated Mr. Baldwin and Mr. Rossi, and his allegations are over a year old. The entire contempt proceedings were ridiculous and unnecessary. It drew their time away from trial preparation. So I stepped in on that, and I've not been paid a dime. I'm going to submit a bill just to watch Gull's head explode, but she's not going to grant it.
So I don't know if you guys caught that. So what he's saying is that, like, and we knew this when he very first stepped up back in October, that he's doing this because he honestly believes this is the right thing to do. He thinks that what's happening is unconstitutional. He thinks that what happened with Rosie and Baldwin was absolutely the incorrect path, and he has stepped up to offer his services. So what he's saying is he's going to submit a bill just to get essentially under Gull's skin. I think anybody who's been in court and anybody who's relayed what they've seen in court can tell there's a bit of a butting of heads between Gull and Hennessy, for sure.
Yeah, but he's a lead pipe, so he can get away with it. That wasn't the part. It's coming next. It relates to Richard's health, and that he can't wait. I forgot about this part. We talked about it earlier. I thought he said, "Watch your head explode," and he really did. But you know, a lead pipe can get away with that. Second, third year lawyer, not so much. But again, it's because, and I haven't confirmed this, but in talking with just a couple of emails I had with PFD on the first original action, and listening to Kara, I'm pretty sure because of Hennessy's contacts was able to secure their pro bono representation, free representation on the original actions. And that's, you know, what a lead pipe will do for you. Somebody that has the core values and experience and the contacts, you know, he's the real deal. There's nothing made up about him. He's a, you know, Hoosier lead pipe carrying MFer defense attorney, and clearly has the respect of the Indiana Defense Bar, and being able to get people to volunteer their time, because he's the type of guy that you know, he's the first one on the ground and the last to leave when it comes to you know, making sure these attorneys aren't bullied off of the case. And anyway, that's all I had to say on that. I think, you know, the real important part on why they're having to ask for funds is coming up in a second.
Okay, I'll keep going.
But you know, I got a couple 100 hours in the thing. But me being able to handle the contempt allowed them to keep their attention on trial preparation.
Right.
You know, the state has an upper hand anyway. Yeah, many people believe after an arrest that they got the right guy, because I counted, they went on TV and said they did over 100 times. And then Andy and Brad do one little press release, and holy cow, you know, they pull out the guillotine.
Yeah.
But yeah, experts are critical in this kind of case. Now, if the state had no experts, you could maybe get away. You would still want some of your own, but they've got them. You know, they've got a ballistics guy. They got a blood spatter guy. They got an odinous expert. They got blood spatter. They got DNA. So the defense needs it.
I'm assuming they're going to have a phone guy. There's got to be forensic.
Oh yeah, I
phone
left
guy.
that out.
Yeah, we've got this whole situation with the geofencing. I mean, and apparently the state doesn't have an answer as to these 3 other phones that were in and around within 60 to 100 yards of where the girls were discovered during the state's timeline, with no answers as to who they are. And it appears that they've done no real research into trying to figure out who was there. So naturally the defense, in terms of their duty to their client, needs to try to figure out who those folks were. I think we all want to know who those folks were. I know I want to know.
Yeah, the prosecution does have a geofencing, and it's called a phone dump. It's a forensic examination of cell phones, which, you know, is basically a small computer these days. And I know they deposed him within the last 2 weeks. So that simply reinforced their need and their judgment that they need a geofencing forensic expert. They've had one that they have been paying and not yet reimbursed for. So that's another one. And, you know, I think that's where they came up with their to 40 estimate today. You know, I've been struggling with one reason I went 25. I was struggling with, I don't want to collect more than we need because I don't know what to do with it. Now, the platform that Allie and you found does allow refunds, but I don't know that I have time to email 460 people to ask them if they want a refund, if there's anything left, that is. So, I don't know. I struggle with that. I can tell you it's going to be held securely. And like Bob said, it's being used solely for experts. Brad and Andy, you know, I mean, they got on board at $100 an hour. That's on them. And, but so we're not going to use it for anything else. But you're right. I mean, like there's an expert, one out of Tennessee, one out of California, one on the East Coast, and we got to get them here, and we got to give them lodging and food. So their fees are not the end of it, and they're substantial. Now we're reaching out to them. A lot of experts will reduce their fees on high profile cases like this because the exposure is worth something to them.
Right.
And a lot of experts that I've used in 41 years, I've employed a lot of experts. And I was a public defender for 15, and many experts have a indigency rate where they cut it down. But generally speaking, experts are $300 to $600 an hour.
Yeah, and the cost for them to testify at trial is higher than the number that they're requiring that they be paid for the research phase or whatever they may be doing. You know, that their trial testimony is typically twice, in my experience, in all my years, of what they are charging us hourly for them to get to the point where they're whatever we're asking them to evaluate. And the other thing that I think that we need to let people know is that attorneys are not experts in scientific fields. I am not an expert in geofencing. I am not an expert in DNA. And we rely as attorneys on those experts to educate us in terms of what we are going to be preparing in terms of cross-examination of the state's witnesses. We are educating ourselves so that we are competent to conduct our examinations of their witnesses and our witnesses. So, I mean, they're critical. They're absolutely critical in terms of being able to really put forth a fair and equitable trial so that the jury is getting both sides of the equation in a way that's in line with the Constitution and its, and its guarantees to us as
Yeah,
citizens. So,
that's another disparity, because at trial, the prosecution goes first. And so they can schedule their witnesses. I mean, they can pretty much guarantee they can fly a guy in the morning, put him on the stand, and then fly him out, and they don't have to pay for hotels or food. Excuse me.
Okay, so I just want to touch base on this really quick because Bob brought it up on the live with Allie and Hennessy, and Travis brought it up earlier. So not only do the expert witnesses, they are like collaborated with, they also are teaching the attorneys. So even if they're not going to actually write a final report for trial, or they're not going to actually testify, what they can do is to give all that information and the questions and poke holes in the depositions of the other experts from the prosecutor's side, in order for the defense team to actually even know what the heck kind of questions to ask if they aren't going to put that expert on the stand. So I think it's a good point to, like, just because we have the knowledge that these experts are being talked to doesn't necessarily mean we're going to see all these experts on the stand, but they have to be able to understand how to present their case on either side.
Just naming an expert can keep their expert honest, so you don't need to bring yours in to testify. You following me? They see you've got a qualified expert that knows what that particular forensic organization considers acceptable, allowable, verifiable testimony. So tool marks, if the National Association of Forensic Tool Mark Examiners have issued a bulletin that says tool mark evidence on an unfired shell cartridge should never be used to include a gun, only exclude a gun. And they deviate from that. They see, oh, you've got the vice president of the association named. It keeps their experts honest. So sometimes you don't even need them. But you said that exactly right, Teresa.
Thanks, Travis. All right, we're going to keep going.
Defense counsel, we never know how long it's going to take. We don't know how long cross-examination is going to be. We generally don't get to know the order of the witnesses. So we have to make a best guess. When can we get our experts on the stand? So generally speaking, we've got to ask them to block out 2 days. I don't know if I can get to you Thursday or Friday. So that's another cost to them and another cost to the defense, because we're going to have to put them in a hotel. So that's just another disparity.
Yeah.
Will any of the experts require additional testing for authorization, which would then require more fees? Is there anything along those lines? Like you mentioned a DNA expert, which I would think would require additional testing be performed, which might have a cost.
Probably not in this case. The investigation was so poor, they didn't make as much effort to recover DNA as they should have. So the expert will be talking about what could have been done, a defense expert. I do not know what their expert's going to say. But yeah, I mean, we need one. At least he's out of Chicago, so he can drive over, or we can send Mata up to get him and he can bring him.
Yeah.
Right, Bob?
100%. Yeah, and I think that in like every single expert that they are intending to put on, the defense has to have a counter. You just can't have a situation where the state is putting experts on and it's going unchecked. Like in a situation where you're having to rely on your cross-examination as the way to counter that when it comes to expert witnesses is not optimal at all. We really need to be able to put our own experts on terms of criminal defense attorneys in order to get what we're saying out to the jury, because the one thing that you'll know, and David will attest, experts for both sides are never caving. You're never getting them to cave completely. You may win certain points during a cross-examination, but in terms of getting them to really change their final opinion, it's very, very difficult to get them to do that. So that's why you need to kind of even the playing field by having your own expert on who has reached a different conclusion, whether it be scientific or otherwise, with respect to what they're saying. So, and
that and also a jury needs to hear a contrary opinion. A jury needs to hear about the process, best practices, and if there's a critique, a valid, reasonable critique for the state's expert, you need an expert to give it. And a jury has a right to hear it. It's important. So they help you, one, attack the credibility of a state expert, and then two, they help you explain to the jury the proper way of doing things and why the state's expert opinion is faulty, and what their opinion is and why it is more well-founded than the state's expert.
Yes. Is there a Photoshop expert by chance?
So this was a great question. Allie, I'm so glad you asked this question. A Photoshop expert.
Say again?
Is there a Photoshop expert by chance?
Not yet, but we have discovered that there is and the state hired them early on, but there's a process, like, you can, the picture of the man on the bridge, you can, there's some algorithm or something, mathematical formula where you can estimate the height of that person based upon the length of the boards on the bridge. And I think the state hired a person about photographs and paid him $5,000, and then for that person to do a analysis of the person's height was going to be another $10,000. So they didn't want to spend it. I personally suspect they didn't want that answer because I don't think it's going to be good for them. We found a college student that did it, but I can't talk about that.
Yeah, so there, I just thought that was extremely interesting. So the expert was going to cost $10,000, and they didn't want to pay that. They didn't want to pay that, but yet they all asked for a raise from the prosecutor's office at the county council, but they didn't actually want to pay the 10 grand to actually figure out how tall this freaking guy on the bridge is. That's crazy to me. All right, we'll keep going. I'm so glad you asked that, Allie. Thank you. And yeah, Photoshop experts, probably not the professional term, but I know exactly what they're. Yeah, it's nothing in his enormous budget. Like, how would you not want of anything? You don't know who the guy is, and you don't even want to know how tall he is. I don't know.
Yeah.
Right.
So David, another thing, kind of a more general thing, and I'm asking some of these questions because these are some of the questions that I've seen raised as this fundraiser has continued. Explain to the people how, if you've got an indigent defendant, that us being defense attorneys going to the judge and thereby going to the county for funds is the norm. It would be abnormal for us not to be asking for the money, because a lot of people are out there like, oh, well, like, why aren't they paying for it out of their own money? I don't understand why the taxpayers are paying for this guy's defense, things like that. So I just wanted, you to be able to explain to the people that may not understand that us asking money for experts happens in nearly every case.
I think people should be wondering why the taxpayers are paying for 7 years worth of an investigation where everything ended up being lost, paying the salaries of all of the people who didn't even make sure that the information for the case was secure. But that's me. I don't live in Indiana.
That I've ever represented an indigent client, meaning that they don't have any money. I have to go to the judge, who has to go to the county for those funds so that we can get those experts and or even investigators. You know, I mean, we have to have those things in order to be able to properly defend our client.
Yeah, the United States Supreme Court established an indigent person's right to investigators, experts, and cost above and beyond representation by a competent attorney in Ake v. Oklahoma, AKE Oklahoma, and that was a long, long time ago. So they have a right to it, and the United States Supreme Court has established that. But if you get a judge that wants to use her judgment instead of two attorneys with 50 years experience, the only remedy is to appellate process. And that'd be another 8 to 12 months. I mean, the whole disqualification thing caused more delay, and she was, clearly wrong. It's unfortunate. I wish the Indiana Supreme Court had disqualified her. And
Yes.
I asked that she recuse herself from the contempt proceedings. Andy and Brad have asked again that she go away.
You can't say that Hennessy holds back. Like, if however Hennessy feels, he's telling you exactly how he feels. It's just like, I wish that they would have just gotten rid of her. I've asked for her to go away. Baldwin and Rosie asked for her to go away. She just won't go away.
Politely. And I don't know why she wants to hold on to this. It reminds me of Gollum with his precious, for the people that know anything about the Lord of the Rings.
One of my favorite movies.
Yeah.
I mean, go ahead, Bob. Sorry. I was just going to say it almost begs the question of whether or not she's being threatened or blackmailed. I have never seen this kind of behavior from a judge on such a high profile case. We're not talking about a domestic violence or burglary situation. And I know that corruption runs deep through all facets of legality. But this being such a high profile case, we have so much focus on this, and some of these acts are completely brazen and just dumbfounding. I have no words.
And before I play the rest of that, I want to say, if you guys aren't subbed to Allie's channel, Unsolved Crimes Uncovered, that is literally the epitome of what her channel is going through and like finding the statistical anomalies that align with the Delphi case. And her comment there just really aligned with exactly how I view her as a, you want to call her content creator or a researcher or whatever it is. That is literally it. It's like, how many people have been threatened? How many crimes have occurred surrounding the people involved in the Delphi case? Statistically, are these crimes acceptable in the number, according to the rest of the country, according to the rest of the state? And then what are how many of these crimes or threats or things happening surrounding this case are just so far above the statistical mean? That's literally what she does. I cannot even describe how intelligent it is to be able to put that information together in a cohesive way and explain it to like people like laymen that are not in, don't do that. It's just, if you're not subbed, I highly recommend subbing.
Ito took a bashing in the Simpson case, and I don't know why mainstream media isn't scrutinizing the judgments, like the contempt hearing. I meant to look this up before I got on, but the contempt, he files and information for contemptuous conduct with allegations stale, over a year old, the day after they get reinstated, and they get a hearing. Whereas I know I personally have had, I know I've seen at least 10 or a dozen or more defense motions or my motions that were denied without a hearing. We can't even get a hearing. And then he gets a ridiculous, unnecessary hearing on spurious contempt allegations.
Mm-hmm.
Yeah, it's a head scratcher. And I just want to address it. I keep seeing some comments out there. David is not at liberty. There is there's not only a gag on this, but he cannot discuss any of the evidence in the case. We have to limit this conversation to what we're talking about, just kind of general concepts of what we're trying to get accomplished here. So we're not purposefully ignoring you, but his hands are tied. What he may or may not know about the evidence in the case. There's a protective order in place as well as the gag. So he's not going to be able to answer those questions. We're not trying to be evasive. He's under a court order, and we're not trying to have Gull toss his butt in jail for a few days, which I'm sure she'd love to do. So he's not going to be able to answer those types of things. So might as well quit asking him.
I know there was early on a lot of questions in the pay to go. CEO called me to confirm that this was not a scam. And in this day and age, I get it. Yeah, I mean, people should be suspicious of basically anything on the internet. Well, except me.
Yeah.
They should not be suspicious of me because I'm a truth speaker. But so we have reached out. Some people have called. We returned their calls. And you look at it on the sheet, there's a lot of people. Well, I don't know about a lot, but like 60 that show up as incomplete. We have 0 decline. So there's 3 categories: donated, incomplete, and decline. We've had no one decline, but there's some incompletes, and I think maybe they were interested. They thought it was important. I mean, I don't know why they would have gone to the page if they didn't think it was important. And then they just got a little queasy about, is this real? So, yeah, I want to, again, thank you, Allie and Bob, because there's 2 main points. 1, it is absolutely necessary. And 2, it's not a scam. And the problem was not created by Mr. Allen. The problem was not created by the defense attorneys. The problem was created with the state having experts and the defense not given any experts, or not given the experts, all of the experts they need.
Right. And I do think that it's very important, as Bob was saying earlier, to remind everyone that this is not a matter of whether or not Mr. Allen is guilty or innocent. This is a matter of due process and a violation of our 6th Amendment constitutional right to a fair trial. So this is a need. It's very important because any one of us could be in a situation like this where we're essentially being railroaded, and without access to a fair trial, without access to proper experts, what chance do we have?
Yeah, I would ask people, look at this case and look at what we're doing right now and ask yourselves whether guilty or innocent. If you had an uncle or a brother or a sister or a mom or a dad going on trial with the prosecution having a half dozen experts and you having none, would you be comfortable? Or would you think that your relative, your close relative, or even just a friend, would you think, holy cow, that's just not right?
I mean, I know I would. You know, it's that thing where you're asking people to kind of to walk a mile in someone else's shoes to try to understand the concept of what this is. This isn't about one case. I can tell you for a fact that David Hennessy and myself, having practiced over 40 years, tried hundreds of cases, won 100 murder cases, that what's going on in this case is not out of the ordinary. We are always up against it when dealing with judges and the state. It just so happens that we have a very bright light that's being shined on this case. To me, it's a systemic issue with our system of justice. It's inherently unequal or unequal, however you want to term it, in terms of us being able to get in there and do what we're sworn. We have a sworn duty to investigate and defend our clients to the best of our ability. And when we can't do that, it should scare everybody in this country. You know, we cannot have a system of government and a system of justice where we're allowed to be railroaded, because believe me when I tell you, when the prosecutor's office, they have an arm of the law in terms of whoever is handling, whether it's county sheriffs, whether it's a police station or a particular police department, whether it's the feds. Those are their arm, their investigative arm that continues to investigate, that continues to try to pull evidence while this whole thing is going on. And they have that at their disposal at all times. We have to get our private investigators out there hustling, trying to do what we can do. Because remember, once they lock in and they develop tunnel vision on one defendant, they're not looking beyond that defendant anymore. And it becomes up to us as defense attorneys. In this case is a perfect example. When Brad and Andy start digging through the discovery, they were like, wow, there seems to be 5 other people that 3 other legitimate cops seem to really investigate for years that apparently have been completely forgotten about and or pushed under the rug by the state, and we're concerned about it. And anybody, like, putting aside the odium side of it, that like so many people got caught up on that. But when you have an individual who's saying that he was at the scene of the crime and had left DNA on one of the girls because he spit on her, and people are choosing to ignore that, it's strange to me. It's strange to me. When I hear something like that, it makes me wonder, what were they doing during the investigation?
People might be, I don't know, sometimes, Bob, I drift off while you're talking, but I swear I heard snores coming out of the class. But people might be interested in the PD system in Indiana. We have 2 state agencies. One is the Indiana Public Defender Council, which does training, support, and they help the trial level attorneys and appellate attorneys and chins and TPR attorneys. So that's a support group. And I was on their board of directors for 39 years. And during that time, their former executive director, Larry Landis, fought like heck to get some kind of system in place to have more continuity in these kinds of issues, and established the Public Defender Commission. So that's an entire separate agency. But the remedy, if we know that indigent people have a right to investigators and experts, but the remedy just takes too long. If it's that serious of a case that everybody wants experts, they're most likely in pretrial detention. And an appellate process can take 8 months to 16 months, and so that's not a good remedy. We could not get the legislature to try to use a stick, so we did convince them to use a carrot, and that is counties. We have 92 counties, and they can elect to be in the system or can elect not to be in the system. If they elect to be in the system, they get reimbursement for felonies, and we're working towards getting them reimbursement for misdemeanors, but they get reimbursement for experts. Like Marion County has an agency, and they simply determine, they have a panel of experienced attorneys, and the attorneys make the request in-house, and then they decide if they're going to about experts. So these are experienced criminal defense attorneys making a decision, not a judge with no criminal defense experience. But so the carrot is reimbursement. Now the commission can't force it. Okay, they have no stick. They can't call up Judge Gull and say, hey, We have reviewed the request from defense counsel and you must grant it. That's not within their authority. What they can do is suspend reimbursement across the board if they determine that it wasn't properly funded and they go out of what we call, they go out of compliance. Both Allen County is in the commission system and Carroll County is in the commission system. So again, I don't know if they're looking at that currently. I know they will look at it eventually. And quite frankly, there's a risk that Carroll County and or Allen County could lose reimbursement.
Yeah, go ahead, Travis. I know that I was going to pause here because I knew you had some stuff to say.
Okay, so 39 years, board member, counsel, what they were set up to do, even more, revamp their system. And they talks about didn't come up with a stick. We have a carrot, which is reimbursement. The thing really got me is he goes, I don't know if they're looking at that county now, but they will be, is what I caught. That
yes.
And if they're determined to be out of compliance, they'll lose all of their reimbursement for, I'm assuming, this fiscal year. Now, he did say both are elected, Allen County and Carroll County are elected to be in the commission, not the council, in the commission, meaning they're entitled to reimbursement. But Allen County is a little bit different in that they have attorneys on staff, hired employees. And then cases where there's more than one defendant, co-defendants, there's a conflict. So the public defender in Allen County can represent one. Then they have to hire outside counsel and pay them hourly for the other attorneys. There's two defendants. One's going to be in the county public defender. One's going to be a private attorney that's qualified to be an appointed public defender. And they rotate, and there's supposed to be equitable systems, and they file plans. Counties that are as small as Carroll County and others, they really don't have enough caseload to hire a full-time attorney to be the public defender. So they do it this way, where they just hire people hourly. But all of them, at least on felonies, are entitled to reimbursement. Hennessy, boy, he's something else. He's the real deal. That thing about Bob and losing track at times when Bob talks. I can empathize, Bob. I can empathize, but sure would have been nice to have somebody like Lead Pipe cracking the joke about it. But yeah,
I love how patient Allie is with having two men on this panel with her that love to talk. Both of these guys love to talk. And she's just so nice and cordial and sweet and just here for it. And then Bob goes on a rant. And then you could tell Hennessy doesn't actually reply to what Bob said. So I think he may have actually just tuned him out. And he was like, all right, Bob's going to talk for like 5 minutes and go on with his life. All right, we're going to play it. I don't know how much more we want to play, but yeah, I know, Raider, you still thinking about going? We're discussing a group in a huge house. I am hoping to be able to go. I'm waiting for a date on one of my daughter's gymnastics competitions, the state competition, before I book a plane ticket. And I kind of just determined that even if I am not in the trial when I'm there, I want to go anyway. So I would much rather go and try to get into the trial than go at a different time and not even have the opportunity. So I think there's plenty of things that I would like to see and do in the area, even if I'm not in the courtroom. So I do want to go for at least a week. But we'll see. I just got to get that last date. All right, we'll keep playing it.
Yeah.
I have a question regarding one of the new attorneys that was added to the prosecution. Her last name is Diener, and it made me wonder if there was a relation between her and Benjamin Diener, who was the previous judge that signed off on the PCA.
So this is a great question because I was going to look further into this. We know it's not his wife, but I am hearing, and I have not confirmed, so please know that this is an unconfirmed statement, that it is potentially Benjamin Diener's sister-in-law. I'm not sure of that, but that is what I was emailed and messaged by two different people, so I have not looked at it myself. We know it's not his wife, but potentially his sister-in-law. That's what I know.
You know,
Do you
I
happen
don't
to know?
She's Brad knows her, and she fairly recently, I want to say within the last year or two, went back to the prosecutor's office and was out in private practice before then. But I have no idea.
Okay.
Why don't you call Judge Diener?
Someone.
Bob, can you go call Judge Diener for us?
Yes, absolutely. Do we know, did she enter a limited appearance like you did, or is she in for the long haul? Do we know?
She has entered a general appearance.
Okay.
And, you know, there was a clip out there with Mr. McClellan talking to their county council or whatever about adding staff and needing money and how much money he needed. So I know he added her after that. I know he got money for some other additional staff, and Brad and Andy don't. They're using their staffs that they were paying and are still paying.
Mm-hmm.
Well, and Brad and Andy's investigators haven't been paid a dime, and they have as you can imagine, in a case like this, they have a pretty hefty bill. And I think the word I heard is that they're paying the investigators $10 an hour, which in Illinois, I believe, is under minimum wage.
Yeah.
So.
Brian Alvey, Matt Hoffman, I know that they've been working on it. And then an earlier guy, Jensen, I know have heard of him. I know he's not working on it anymore. But Brian Alvey and Matt Hoffman just have big hearts.
Yeah.
Not as big as mine, because I represented the attorneys on the contempt proceeding. And I spent a couple hundred hours. And I had to drive to Allen County against my wishes.
Yes, you did. And that's a long drive. It's a long drive.
Mm-hmm.
It is. All right.
All right, I think we're probably going to wrap it up right there. You're welcome to go watch it on. Let me go find her link real quick again and watch the rest of it on her channel, and give her a like. And Travis, anything that you want to add to the commentary from today?
I apologize. I must have gotten a phone call from my day job, and there was a bigger gap than I thought. But in a minute, I think he's going to mention that the reason, why they asked for funds, they kind of already covered that doing an interlocutory appeal, he says 6 months, even, up to a year. Later on, he will say, if you didn't catch it when it was live, that they just don't have the luxury of that kind of time. My recollection is he said he didn't think Richard would be able to last that long under the current condition that he's under. So the last thing I wanted to say about it, Teresa, well, first, thank you for having me on. Always enjoy.
It's my honor always to have you and for you to help me understand what we're talking about.
So I hope we answered some questions on the raising the money between the presentation that you've been showing and our comments. Look, I don't have an issue with anyone having full knowledge of the campaign to raise money for experts, but for whatever reason, just, you know, they're not going to contribute to it. I have no qualms with that whatsoever, and I make no judgments about that whatsoever. What I do have a problem with is people trying to shame those that have given, or shame and comments about those people giving to it. We don't always agree about everything, but you know, America's a funny place when it comes to our civil rights. And he mentioned we pronounce it Aki and AKE in Oklahoma, but yeah, that's a Supreme Court case that says you're entitled to effective representation, effective assistance of counsel. If you don't have effective assistance of counsel, the case will be reversed and you'll get new counsel who is effective. But part of being effective, for an attorney to be effective, is he has to have the necessary, he or she, please forgive me, they need to have the proper experts and investigators in order to truly represent a defendant effectively. I don't make any judgments about people that look at it and say, look, you know, I just don't know, and or I think one way and I just can't get around it. That's not helping him, a guilty person, you know, whatever the reason. I get that, and I make no judgments about it. But people that are contributing and think it's worthwhile for the defense to have a level playing field, as the U.S. Supreme Court has declared over and over and over again. You know, I really take exception to that. That's not what we're about in this country. Some of these rights go back 10 centuries. Been seeing people say correctly that, you know, these are constitutional rights. If you violate them against one person, they can violate them against any, and that's true. But these rights that we're talking about go back 10 centuries in England, and our founding fathers and the framers of the Constitution, and Madison, when he wrote the 13 provisions of the Bill of Rights that were reduced to 10 that we're familiar with, has been interpreted. You know, these are long, hard fought battles. The right to an attorney in a felony case, Gideon, that you're all familiar with, and Henry Fonda, that's Peter Fonda's dad for most of you. But he played this gentleman in Florida. That case was in the early 60s that was decided. And some of these rights are relatively new. Some have even come when I started actually practicing law, which was 40 something years ago. And, you know, if you look at everything and your conscience tells you that you want to contribute, please do so. And you can do so free of guilt. It's not a scam. It's not making a declaration on who's innocent, who's guilty, what justice is, anything like that. It's just getting Richard Allen what our law says he's entitled to, but for a variety of reasons, just isn't able to get something basic. as simple as getting a pen and a legal pad to defend him with. And it's been explained to you why the necessity, but you shouldn't have any guilt whatsoever by contributing. In fact, you should feel damn good about yourselves, because that's what we're about in America, the underdog, coming here and enjoying all the rights, all the liberties, all the fruits, all that stuff we used to learn in civics that I don't think they teach the younger generation anymore. And, you know, and if you're trying to shame people for contributing to this fund, shame on you. That's all I got. Thanks for having me, Teresa. Sincerely, thank you.
No, sincerely, thank you. And I know everybody's showing you all the love, and I was trying to post them all for you, so hopefully you could see them. Everybody's very appreciative of you being here and giving us, you know, the knowledge that you have and sharing that with the chat. And so we understand what we're looking at so much better. So I appreciate you, you know, and especially if you take the time to like break down like your comments on the documents, it makes it a lot easier. So I thank you for that.
You're so welcome. For those to celebrate, I hope you have a wonderful and safe Easter. For those that don't, I hope the Easter Bunny is good to you. And whatever your faith or whatever you believe, hope you and your family enjoy the weekend. A week from Monday, the Odinists of Indiana are working on a spell to create total darkness for about 4 minutes over most of Indiana. So we'll see how real Odinism is in Indiana. For those that don't understand my sense of humor, it's a joke. There's a total solar eclipse that goes through Mexico, up through San Antonio, the hill country of Texas, Dallas, and all the way up into Indiana, right through Indianapolis. But
well, you know, the Odins aren't just in Indiana; they are across all those states that you just mentioned.
I wasn't going to let on to that, but the Odinists we have are it's a prison game. We also have a motorcycle game, the Odinists, but you know, you've had people on that have explained the complexity. So you kind of have a prison gang, and then you kind of have a real pagan heathenism, Nordic heathenism, and you know, I understand that there's pagan beliefs around that, and well, you know, one thing we've talked about, I don't think for those fortunate enough to be able to sit through part or all of the trial, that you're going to see the defense saying this was a ritual sacrifice, or they're going to say that this particular person did it because you know, they're an Odinist. I think what you're going to see is them showing kind of what Bob alluded to. And again, I don't know the facts like Teresa and Bob and others do. I just know the general stuff. But he rattled off 5 people that kind of came out of this hearing, and one saying, "Hey, I can explain," or something about explaining spitting and his saliva DNA being found on one of the girls, and you know, some really crazy stuff. I think what you're going to see, how it's going to be raised, is that the bias of the investigation and the sloppy investigation and the negligent investigation, and 3 or how many ever detectives pursuing one line and one theory and being in disagreement with others. We call that kind of stuff reasonable doubt. Now, they may zero in on somebody that happens to follow Odinism or in general Nordic heathenism, but they didn't go out and look for it or look at the photos and say, man, this is a tough one. Maybe we can hire an expert and they'll say those are runes. This was dumped in their lap, so to speak, where 2 or 3 investigators were pursuing that. Others, there's a disagreement. People are off the investigation. They're, and so that's where I think it's going to come from. And that explains why, they've got an expert, the state does, on Odinism now to say why an Odinism theory isn't viable, why they got off Odinism and that it was a rabbit trail. And so that's interesting. The state's hired an expert to explain why the investigation was going a certain way. So that's it. Enjoy your Easter, everybody, if so inclined, or safe weekend.
Yes, and right back to you too. Enjoy your Easter weekend. I got kids on spring break next week, so that should be fun. Oh, Shiraz, thank you so much for the gifted memberships. Thank you. Thank you. And Radar, I don't see that comment, so I will take a look again after the live just to double check. Maybe one of the mods actually grabbed it for you. So, but again, Travis, thank you. I'm gonna end it, and you're welcome to stick around if you want to. I just say goodbye to everybody and just say thank you guys for being here. And I know we've been 4.5 hours in. It's been a lot of information. I will go back and actually timestamp it. So if you're just interested in a certain part on replay, you can find yourself the exact spot that you want to go to. But other than that, it's a happy Friday night, happy Easter, happy weekend. If you don't celebrate Easter, I was considering maybe doing another Saturday night live like we did last week, but I don't know. You guys are kind of troublemakers on Saturday nights, so I don't know. We'll see what happens. Anyway, I know that you guys have 1,000 other places that you could spend your time, and you choose to spend your time here with me. And it's extremely humbling that anybody cares about what I have to say. But tonight I feel like you guys were probably sticking around for Travis, which I totally understand. So thank you for that too. But I will see you guys on the next one. Enjoy.